Very lost. My lord, I am a higher secondary school teacher. I was placed under suspension. Thereafter, that was withdrawn, but in between, the salaries have not been paid, for which my service is not continuation. So it may kindly be listed day after tomorrow.
Fresh or full matter? New matter?
It is a matter of 2024. But thing is, this
Day
my lord,
after tomorrow will not be possible. We'll have it next week, 6.
6
Monday.
5 of light.
May I please, Lordship? So two matter relating to payment of salary, Lordship. I am praying for a listing on 8 of May, Lordship.
8 or 12. All right, 8.
May I please, Your Lordship? My lord, for listing, my lord, non-payment of salary, my lord. On 8, my lord.
8.
May it please, Your Lordship? Lordship, I beg to mention a series of matter pertaining to tax, Lordship. Can it be on 6th?
May please, Your Lordship. Lordship, I beg to mention item number 20, Your Lordship. Lordship, another matter is fixed by Your Lordship on 21/5. This matter will be tagged with along with that matter, Your Lordship.
It is submitted by Mr. I. Ahmed.
Lordship.
That similar matter listed on
21st. This is the read petition
the
number
WPC number
8398/2022.
8398
Yes, 2022.
of 2020. It is submitted that this writ petition be listed along with the WPC 8398/2022 on 21st of the prayer made is allowed. Please report.
Deep level.
May I please, Your Lordship? Lordship, I am mentioning the matter item number 74. We will file affidavit today, Lordship. It may be taken up any other date, Lordship.
74.
Yes, Lordship.
Who's for the petitioner?
I am happy for the petitioner. I have no objection.
You have no objection. You have no objection. Counsel for the respondent submits that an affidavit in opposition by the submitted that an affidavit is counsel for the petitioner does not object. That's the matter of no. You go through the affidavit, you may like to file a reply. How do you know? Let the affidavit be on record. You make a mention thereof. Yes.
May I please, Your Lordship? With the consent of the other side, Your Lordship, I beg to mention item number 30 of the daily list, Your Lordship.
30.
Yes, Lordship. The youngest counsel was not well, Your Lordship. Kindly adjourn the meeting, Your Lordship.
Who is not well?
M. Das, Your Lordship.
Mention is made on behalf of the counsel for the petitioner that the counsel is on this post. Therefore, the an adjournment is sought for. Accordingly, matter will be taken up. MS G. Borderline.
G. Paul.
Bora. On behalf of the counsel.
Much obliged.
I beg to mention item number 25 and 26.
25, 26. Yes.
I am praying for adjournment of 2 weeks, sir.
Item 25, 26. Any objection from
Government, sir.
opposite side? Item 25, 26. That's a request to the council. Stand adjourned for 3 weeks.
May I please, Lordship? I beg to mention item number 4. My senior is on leave and the letter of absent has been given. Kindly pick
You
the
are
matter,
hearing on behalf of the petitioner.
petitioner.
It is submitted that counsel for the arguing counsel for the petitioner. Who is the petitioner? Who is the
D.
counsel?
T. Bora.
It's the D. Bora. He is absent. And a letter of absence is and public. Adjournment is prayed for. Any objection from the respondent? Prayer made is not objected to by the respondent accordingly. Matter stands deferred for 2 weeks. How many days is he seeking leave of absence?
My Lordship, repeat
Okay, be listed after
today, till today, my Lordship.
Okay.
May I please, Honor, my lord, with the consent of the other side, my lord, I beg to mention item number 24, my lord. Kindly pass over for the day, my lord.
24 at the request of counsel for the respondent
Petitioner, my lord.
petitioner. stands different. Be listed after 2 weeks. Prayer made by the petitioner is not objected by.
Most of the
My pleasure, Lordship. So kindly listing for, I mentioned for listing, my lord, writ petition, that help her to work out
For
for promotion,
promotion is not before this.
sorry.
Promotion is not here.
May I please, Your Lordship? Lordship, I beg to mention for listing of a writ petition, matter pertains to Lordship, non-payment of retirement benefits. So in last occasion, the IA was disposed of. So matter may come up for motion on 8.
Motion or admission?
Lordship, motion.
Motion on 8.
God bless Lordship.
My pleasure, recommend the item number 19, my lord. Kindly attend for that on behalf of S Superintendent.
Item 19.
19.
Request is made on behalf of the council. The matter be entered for the day. Prayer made is not objected to. Mr. Lord Pujari, any objections?
No, my lord.
No objection. We have to respond. Six.
Bless me.
Here, who is appearing for respondent? Instructions, any?
No, Your Lordship, we are yet to receive the instructions.
Yet to receive. You are
At
under
least-
suspension.
Yes, Your Lordship.
How
At least
when-
at the
When were you suspended? 22.
2023, Your Lordship. So
Your subsistence allowance
only, that has not, it is holding,
not being paid.
not being paid. And other 2 persons who were also action has been taken on in pursuance of that order 22/11/2023, Your Lordship. They are enjoying the allowances. So at
Then,
least in this,
No disciplinary proceeding.
yes, no.
We heard letter counsel to the parties by a earlier order dated 9/4/2024. Instruction was of permitted obtained by the respondent. When the matter is called up, is submitted that instructions have not yet been received and the prayer will wait for further time. Meanwhile, counsel to the petitioner that petitioner has been under suspension for more than 4 months, yet no subsistence allowance has yet been paid. Nor any review of suspension has been. Shall we issue notice? Such circumstances, issue notice and 3 weeks. If there is confidence, if there is practice, the authorities concerned, MS Serangi appears for education department. That is respondent 1,
Oh, Your Lordship.
4. Mr. Lord Pujari appears for respondent number 6. And Mr. Ora appears for respondent 3. Steps be taken by registered post as the usual court and respondent 5 within a period of 1 week. Meanwhile, the respondent authority, who has placed you under suspension? Director,
Yes, Your Lordship. He is the disciplinary authority as well.
the respondent, more particularly the respondent number 2, is directed to please the subsistence allowance payable to the petitioner as per the provisions of law. Without further delay. Let the matter be listed after 3 weeks.
My lord, may please, my lord, the name of the finance may be shown in the court.
The name
Perhaps
of
they have not
standing
served copy.
council, including education, state government as well as finance department, be reflected in the board by the text. Yes, instructions.
My lord, yet to receive my lord.
I think notice should be issued.
Or my lord, if your lordship permits, I may. My lord, it is from the competent authority, it has been furnished, the documents, the annexure 16, that is by the DI as well as the. My lord, annexure 14 is DI issued the non-royal certificate, that is page 41, with countersigned by the treasury. And the entire amount is given in the annexure 16, that is page 43 to 59.
Yeah.
And my lord, this amount is of 2,83,000. My lord, let them verify, and if I'm entitled, let them pay it. Is the refixation amount, my lord.
Who is to release?
My lord, Director of Elementary Education. It is pending before the DEO. DEO should forward to the director, and director will look into, examine the matter, my lord.
By your order. He respectfully prayer for further time. Complete the instruction. Renew. Let the matter be listed again after 2 weeks. By which date it is not as with the instruction as what steps that be taken for release of the revised area salary amounting to rupees 283,016 respect of the requisition by the respondent department. You have served extra copy.
Yes.
Matter be listed after. So they provided. Are provided. Yes. Respondent 5 and 6.
My lord, item 3 is already IS is already forwarded before the Director of Secondary Education.
Secondary, elementary.
First one is the elementary, second one is the secondary.
Same order.
Well, it's same order, but I think secondary, I don't know if my friend can appear.
Yeah.
Secondary.
Same order. And name of there are three for secondary. And Mr. Report to the report.
6 and 7, my lord.
Both the matters be together.
My lord, date may kindly repeat.
Date
Yes, my lord.
27. 27.
Deeply obliged, my
May I please, your lordship? Lordship, the petitioner number 1 is the second wife, lordship of deceased employee, lord. And petition number 2 is the minor daughter, lord. Your lordship, the respondent number 7 is the first wife, lord.
What is the basis of your document?
Lordship,
Statement. What documents do you rely on that you are the second wife?
lordship, I have the next ID card, lordship. Two
Where is
ID
the
cards,
ID card?
lordship.
Page-
And
Page number.
page number 25, lordship. And lordship, next lordship, Aadhaar card also I have a next lordship. Page 27, type 4. And second petitioner lordship, his birth certificate and Aadhaar card has been.
These are not documents to show that you are the daughter of so and so or wife of so and so.
Lordship,
It's a fact. It's a matter of fact.
lordship.
Unless you have a proper certificate by a proper authority saying that you are the second wife or you have a marriage certificate,
There is no marriage certificate, lordship.
then,
Marriage was lordship.
then you have to go to the civil court.
As per Hindu lordship,
You go to the civil court and ascertain your claim.
lordship, and my daughter lordship is the second.
Where is the
Petitioner.
birth certificate?
Birth certificate, your lordship.
How will the authority verify? Who is this Anil Borgohain?
I have submitted applications before the lordship.
Is there only, is it your claim that in this part of the region there is only one Anil Borgohain?
No, lordship, what happened, lordship? I am living with in my house of my husband, lordship. This is husband, lordship. And the respondent number 7 is residing in a different village, lordship. That's why he has not included my particulars in the pension form, lordship. That's why
And
I'm-
there has to be a basis. How do we find out the veracity of your claim that
lordship.
you are the wife? Who will make this statement?
And lordship, one lordship certificate issued by Gavura of our village also, lordship. I have annexed, lordship. That was
Your forum is the civil court.
that shows that, lordship.
Your forum is the civil. Did you pray for any maintenance? Is there any judicial order?
No, lordship, because my husband died during the lordship service, lordship, died in harness,
Like, you are the second wife.
lordship. Petition number 1 is the second wife.
Yes.
And
On
petition
what
number 2,
basis do we entertain your claim?
lordship, may kindly see page 25, lordship, 35, lordship, 34 and 30,
34 and
lordship. The government Gavura of this village, lordship, issued certificate, lordship, where said that the respondent number 7 is also included here, lordship, and his sons and daughters also included, lordship.
this will have to be
Right.
properly examined. You file a suit called the Gaonpura. Let there be a finding that this certificate issued is a valid certificate was issued. Or you
Lordship,
get some witnesses. On what
Let the
basis do we
lordship-
make on what basis are you making a claim that you're the wife?
lordship, let the respondent authority, lordship, verify, lordship, my
No,
claim.
no.
I have,
How will they verify? That's the whole point. How will they verify?
they can, lordship, inquire, lordship, so, lordship, they are.
How? Tell us
official.
the procedure, how they will verify. They can't call the Gaonpura and
Right.
take evidence.
Right.
And even if they do it will have no sanctity.
The problem is that, lordship, there is no certificate regarding marriage.
Then you file a suit.
And my husband also died, lord.
So you file a suit for its declaration of the right title, interest. We don't find any, how will the authorities verify that you're the second wife, the daughter of the born out of the second marriage? Nothing is mentioned here.
Respondent authority can inquire, lordship.
How? From whom? From whom will they inquire?
If the village headman will can.
So that procedure you do it through the court. You file a suit.
And I have in the year 2018 also I have filed application, lordship, and 23 also I have filed application.
You must show us that you have a right. As of now, your right is not even established. You have to establish that yes, you are the second wife on the
And-
basis of some certificate by competent authority, on the basis of some judicial finding. You are the second wife.
Yes,
She is the daughter born out of the second marriage.
Lord.
Where is that finding? Gaonpura is not the authority.
Lordship, birth certificate of this second petition also shows that the
Yes, it shows that there is
And-
some Anil Borgohain. Who is
Anil-
this Anil Borgohain?
and address is also same, Lord. And I have annexed the death certificate also of the Anil Buraga.
We cannot issue a direct authority. We cannot embark on finding on a fact finding. There is any other way, any other order you want? Tell us.
Then I may be allowed to file a case representation before the lordship pension disbursement.
File. Why do you need a permission?
I have filed earlier also before the lordship SP on 2 occasions. So
The
They have
moment
not-
we issue a direction,
they have
then
not,
we must tell them that they must verify. How will they verify?
they may consider lordship
Consider for what purpose?
for the purpose of lordship. Okay, at least my daughter, minor daughter, he is lordship.
Your minor daughter, that she is born out of the second marriage, what is the material before the authority? A birth certificate saying that this is the name and this is the address. To what extent? There has to be a finding by court. There has to be a finding by the court. We'll give you permission to file a suit if you want.
Husband is not alive. Lordship.
It's not alive, what will be done? We'll have it on Friday, you think over. I don't, I don't find any merit. It will be listed on Friday. That is what.
I am
hearing
for it, Lord.
As, the learner council, like, rely on them. You'd like to readdress the court in support of his argument that the petitioner is the second wife. Petitioner one and two are the second wife and daughter respectively of 14 and submit such further or other document as may be available in support. The keyboard,
Bhattacharya.
is for the accountant
Account.
is not right.
Obliged, Lordship.
Matter is regarding advance increment, Your Lordship, the teachers of acquiring BTBR degree, Lordship, and they are assistant teacher in various high school and higher secondary school, Lordship, and
Similar order.
similar, yes, similar, maybe it is.
Yes,
Lordship, I'm appearing on behalf of RB Bora, Season Election Code 1. Lordship.
you verify that order at 64, he's praying for a similar order. You verify and tell us. We'll take it up after a while. After a while.
Lordship.
Your Lordship. Lordship, the petitioners, they were appointed in the year 2001 as a stipendiary teacher. With the condition that the government will send them to undergo for basic training, and after passing the training, they will be given a regular time scale of pay. So in the year 2005, they were sent for training, my lord. And
Yes.
so in the year 2005, the petitioners, they were sent by the government to undergo basic training. And after completion, they were given the time scale of pay with effect from 31/8/2006. So thereafter, my lord, the Accountant General, Office of the Accountant General, they provided the GPF account number, but that was stopped in the year 2010. For the reason that, my lord, they were given the benefit of time scale after 1/2/2005.
You are asking for similar,
Order, my lord.
Mr. Borputari?
So can be disposed of with a direction to the authorities to make a verification whether they are entitled. My lord, as per, if lordship comes to page 159 of the writ petition, my lord.
Yeah.
That is a part of, my lord, that Purnima Hore decision.
My lord.
Page 159, paragraph 118.
Yes.
The last paragraph. In the backdrop of the above, this court therefore disposes of the instant matter with the following observation. The writ petitioners who come within the fold of stipendiary teachers are entitled.
We will look into this.
Yes. The education department will do the necessary verification exercise and then they will forward, my lord, to the finance.
Yes, Mr. Borwa?
I am appearing on behalf of Accountant General, any some direction may be disposed of. I don't have any objection. With regard to my lord, petitioner, I have seen 5 petitioners out of 8 petitioners, 5 petitioners file application to the authority concerned. Let them file proper representation with this one or all this. Because this, I have gone through this, out of 9 petitioners, I have seen that 5 petitioners have filed representation to concerned authority. Let them go, because AG will look into matter.
No, there is a direction.
Yes.
No, direction is there.
Their claims will be verified by the authority.
Yes, that is why they have to first go, file representation,
Not necessarily.
because they have to file
The authorities will see the moment they, with this order, once they go, that will be treated as a representation. And the verification. will be-
They have to pray, make prayer. Authorities.
Hard. Hard. Similar orders are there. Help along with the director. Yes.
I'm for 4 million.
My lord, at time frame may be given, my lord, otherwise, my lord, I have to file the
Whatever
represent.
time frame is there, if it is not there, it is not there.
Yeah.
We are passing a similar order.
My lord.
Okay.
Oblige, my lord.
Yes.
May I please? My husband rendered his services as a constable in Assam Police Battalion, Ligiri Pukuli, Nazira, in that district.
Your husband expired.
Yes, Lord. He died by illness, that is on 22/9/2019, and expired your Lord. And after death of my husband, Lordship, I approached before the authority for granting pension, I benefit, Lordship. But denying the same, Lordship, I have also approached before this honorable court. And in the meantime, Lordship, the authority has let me know.
What is your prayer?
Lordship, my prayer is, Lordship, for granting the leave area, Lordship.
Leave wages.
Yes, leave wages, Lordship.
You are in receipt of family pension.
No, Lordship, yet to be received, Lordship.
But that is not your
Authority
prayer.
has let me know that my husband got VRS, Lordship, and same has been under challenge before this honorable court, Lordship, and pending, Lordship. But Lordship, in the meantime, Lordship, I have filed an RTI application before the authority, Lordship. So, Lordship, RTI application dated Annexer J, Lordship, page number 51, Lordship, and be paid. Page number 51.
Yes.
Lordship. And Lordship, I am reading, Lordship, only relevant point, Lordship. Please be furnished a copy of daily attendance of his service career effect from 1st of January 2016 to 36 2018. During the aforesaid period, how many days he was attended in his duties in a calendar year? Please be furnished.
Page
record.
51.
51, Lordship, Annexer I, your Lordship.
No, 51 is Annexer J.
Oh,
Annexer I.
49, Lordship. 49. 49.
This is your application.
Yes, Lord. RTI application, Lordship.
And the reply
After
is
receive this,
59, 51.
yes, Lord. Authority stated that, Lordship, they are exempted from purview of RTI application to furnish the information. As agreed, Lordship, I have again filed another RTI first appeal, Lordship, before the competent authority, that is the Inspector General of Police, Lordship, Annexer K, page number 54, your Lord. And thereafter, Lordship, the state authority has furnished me the following document, Lord. Annexer L, Lordship, page number 57. Wherein categorically mentioned, your Lordship, that Annexer L1, Lordship, page number 59, Lordship, stated that, Lordship, that number one, record are available in this unit from 1st January 2016 to 30 June 2018. Total service record are as follows. Number one, total service 912 days. A, medical gown earned leave 80 days. B, hospital leave 89 days. C, commuted leave 198 days. And for LWP 4 days. EOL 103 lot 103 days. Accordingly, 474 days Lordship total service, Lordship, who was on leave, Lordship, and same has been duly sanctioned before the authority, Lord. But the state leave salary was not credited into the account of my husband, Lordship, during his existence of life, Lord, during his service period, Lord. Even, Lordship, no disciplinary proceeding has been conducted. Same has been already stated authority itself, Lordship.
Which salary are you asking for? Is 912 days?
Yes, Lordship, total 912 days, Lordship, total service period, Lordship. Maybe Lordship excluded the 474 days, Lordship, another period, some salary has been credited. After scrutiny, Lordship, it has been came to know that Lordship, some amount has been credited into his account during his service period, Lord.
Yes, what do you say, Mr. Pora?
Your Lordship, at this stage, let notice be issued because I am totally in the blind. I don't have any instructions. Right?
Hard learning company. 4 weeks. Mr. P. Pora, yes.
1, 4, and 5.
1, 4, and 5. Airport,
I therefore I
Mr. P. Sharma. He is studying for
You will strongly leave.
Extra time.
I took place
Within a period.
in the criminal leave
Leave
of
of
pay.
with the response.
Okay.
With the response.
I don't know why we don't know that. Nothing because
Is this matter along with what is the other WPC?
There are two number of WPC, Lordship, one of
Yep.
pensionary benefit, another is challenging VRS, Lordship.
They are pending.
Yes, Lord, pending.
What is the number?
Yes, Lord. In para number 8, Lordship, 4822,
If
And-
it has been listed along with WPC 4822,
oblique 23,
23,
and another one is 1788, oblique 23, Lord.
1788 or
20. Highly obliged.
Yeah, clear. What is the petitioner also after serving for 23 years, 10 years, he has retired from service on 1/10/2021 on VRS due to some medical ground losses. And losses only her GPA has been relieved, but losses the other retired duties such as gratuity and leave encashment and her pension has not been finalized. Now, lordship, they have given to understand lordship that there is some wrong decision in the year 2016. And that is why they have calculated an excess dual amount of rupees 2,14,433. That impugn order is at page annexure 6, page 33. Lord.
Yeah. Yes.
Page 33, Lordship, annexure 6.
Yes.
Pay as on 1/4/2016 has been corrected and refixed at rupees 41,130 per month with effect from 1/4/2016 to 30/9/2020 with due entry and attestation has been made in the service book. For excess dual recovery, the pay statement of the retiree is enclosed herewith for necessary deduction from the discharge amount. Lots of that calculation they have done at page 34.
So they have started deducting or
No, Lordship, they have not done it, Lordship. I'm praying for stay of this order, Lordship, and also praying for a similar order at page 41. Similar issue has been decided by the Honorable Court. In view of Rafiq Masjid's case, no recovery from retired person. And to make due verification, if the wrong is not attributable to me, then they will have to release it at page 41. Lordship.
yes.
Lordship, it is covered by Rafiq Masih case. Lordship.
Hard to school. 848.
Right.
For the report.
Problem.
May it please the lordship. Lordship, kindly the matter may be passed over for the time being. My senior is in election court number 7.
That would give.
Yes, lordship.
Yes.
Yeah, that matter, my lord, transfer has been made during, my lord, the operation of that election commission, my lord, direction, my lord. And as per election commissioner, my lord, district election officer, my lord, the petitioners were appointed as the sector officer. And the circular direction of election commission was that if anyone is appointed sector officer, they should not be transferred. So that has been challenged.
Yes. Now, what is the stage now? Election is over.
Yes, my lord. The release order that on the other day, my lord, your lordship was pleased to issue notice. And what has occasioned the respondent to release in the middle, my lord, after 3 orders were passed by the district election commissioner, election officer, appointing the petitioner as the sector officer, one on 1st January, another on 25 February, another on 15 March. As soon as the status quo order passed by the school, so my lord, the district election officer, my lord, he has prompted and issued the release order, my lord. That was telling, but subsequently it was stayed by themselves. Then again, they have taken leave of this court. So we have telling that release order, my lord, that your lordship was issued on the last day, last occasion, your lordship was issued notice, my lord, on that release order, my lord. At the relevant time. Now, when the transfer was made, that time, my lord, the transfer order was not valid. My lord. This is my case, my lord. The transfer order was passed on 29 February. And from 1st January 2024, we have been appointed as the sector officer. And again, 29 February. Subsequently, after this transfer order, also we have been appointed as
What is to be done?
notice to be issued, my lord. Let them find.
On the last occasion, your lordship, on 4/4/24, your lordship, the leave of this honorable court was taken in regard to removal of the petitioner as a sector officer, your lordship. So it was only that point was, your lordship, which was giving him the sanctuary, your lordship, protection that was granted to him. Now that was removed, considering, your lordship, 2 aspects, your lordship. The petitioner was in the home district for more than 3 years. In fact, he was there for nearly around 17 years, your lordship. So, your lordship, the election commission, your lordship, and the CEO have taken leave of this honorable court on the last. Now, what has happened, your lordship? Election is also over. Your lordship, in the second phase election, it's over, your lordship. Now, this matter may, your lordship, maybe your lordship may direct the RC as the appointing authority, your lordship, to consider the case of the petition. Because otherwise, your lordship, the transfer, your lordship, it was a common order, more than 200 officers were transferred, your lordship, pursuant to the election commission guidelines.
You are no longer a sector officer.
Yeah, no longer
a
sector officer. No longer, I am no longer sector officer.
Therefore, there is nothing wrong with the order now. It don't edit stand way.
Well, order, my lord, that the relevant day, my lord. It was not in. Yes. So no, they have come with the record, my lord. Means let them file reply or whatever he said that register may pass the appropriate order. Now what will happen to us?
There is a stay order.
Yes, my lord.
There was
Now
a transfer order.
Yes, my lord.
Which at the relevant point in time you said you are the sector officer.
Yes, my lord.
It's an interim order. Now during the course of this, you have to be the sector officer. Which order you have held separate. Now your very ground on which held this writ petition not there. You're no longer a sector officer. So what is wrong with the order?
No, my lord, that on the day of transfer order, my lord, on 25 February. On that day, that transfer order was not, my lord, Obama. It cannot be.
It is like making an argument that way I am here, and subsequently some transfer order was passed. But on that day, there was a promise.
Now, my lord, I am not claiming any stay order, my lord. Now, I have a stay order is up to, my lord, the 23rd.
It was still only till the next date, your lordship. Order was suspended.
I'm not pressing because since we have challenged this order, my lord,
No interim order.
there's no interim order, notice may be issued, my, no interim order. Because I have,
Why you don't at all?
no, but the risk factor is there because we have come against the, my lord, administrative officer. my- That's why, like,
The exigency of service here.
no, no, my lord, an order, my lord, finding of this honorable court or decision of the honorable court is necessary, my lord. Because on the day when we have challenged the transfer order, that day it was not.
Because of that, after the release, you had filed another writ petition.
Yeah, that is against the release order only. Only telling the release order. What is occasion?
What is there in the second writ petition? 153.
No, second writ petition is same, two writ petition. Same, two writ petition. One is the two writ petition. The other is not.
In that writ petition, we are not made a part. Corporation.
No, it Adi Hanai. Only with the, I know don't demand because my lord, we have challenged. Notice may be issued, my. I am not pressing for any interim order now.
Lordship, there is, earlier also, your lordship, one writ petition was filed. Your lordship, the Senate Council has filed one, Arlene Rongharti, your lordship, the writ petition is 1656/2024, your lordship. In that matter, your lordship, the petitioner was pregnant, your lordship, at that time. So this honorable court had, your lordship, directed the principal secretary to take a decision, your lordship, and it was disposed of.
We want to know what is being decided here. For issuing notice, there must be, we are calling upon them to respond for what?
No, on the period, my lord, when it was operative, till release order, my lord, it was. Or my lord, the approved order may be passed with the principal secretary.
That is academic. Because your release of sector.
Yes, my lord, yes.
You are already challenging by way of a separate.
Yes, separate writ petition.
Whether it's correct or wrong or anything.
Yes, my lord, yes, my lord. So this was also, my lord, this was also, my lord, notice may be issued, my lord. I will be said with, otherwise, my lord, other action will come, my lord.
For what purpose?
No, the relevant time.
You see your prayer.
Yes, my lord, yes, sir, yes, my lord.
See your prayer. Prayer number 1, setting aside transfer order.
Yes.
Prayer number 2, setting aside order. Prayer number 3, allowed to be continued. That's all. Now the setting aside has to be on German reason.
Yes, on the.
Which you pleaded before the court that you are a sector officer. It's not there today.
Of course, my lord. But on the day of transfer order, we were sector officer.
That is gone today.
That is in the other writ petition, my lord. Your lordship will decide what is occasion.
Whatever is decided, what benefits come to you.
No, if the release order is illegal, automatically it survives, man.
The release order is illegal.
Yes.
That the direction can be issued by the state court. Order.
That the election will be over. And transfer order is only, my lord, passed in the during this election hours, man. Only it is operative only in election hours.
Very well, we record it and put it that after elected government.
Yes, my lord. Yes, my lord. Yes, that may be.
Yes, sir.
Yes.
Fine. Challenge. Transfer. Page 35.
Yes, my lord.
The order of transfer dated 25/2/2024.
At serial number 195.
Whereby the senior inspector / auditor of the cooperative society mentioned in the order are shown to be transferred in their places postly. Insofar as the petitioner in the first petition is concerned, is that serial number
195.
His name appears at serial number 195.
Page 41.
195. And petitioner in the second writ petition, serial number appears at
198.
The petitioner Sanjay Burman was transferred to DRCS Nalbari, whereas the petitioner Noor Ahmed Loskor was transferred in the office of ARCS Nagaon. Both the petitioners were working as what? Senior
Inspector.
Huh?
Senior inspector.
Are working as senior inspector under the Department of Cooperative. So, the demand of the petitioner are that as per these transfers are made in view of the general election to the House of the People within bracket Lok Sabha 2024 by the Election Commission of India. Now, insofar as the petitioners are concerned, it is heard that they are excluded from the transfer by operation of clause 6 of the
Guidelines.
of the Election Commission of India communicated by
20 and 12/23.
communication number so and so dated 21/12/2023. So, under clause 6 of the said guideline, officers who were appointed as sector officers / zonal magistrate involved in election duty are not covered by the instruction. So, it is the submission of the learned council that by order dated 29/2/2024, the petitioners have been appointed as sector officer, civil sector officer. Their names appear at serial number
115 at page 30.
115. 115 and
116.
116.
No,
Not 116.
Not the 116, my lord. There is on 83. 84, my lord, page 26.
115
and 84, page 26.
serial number 84. Stop. The learned counsel for the petitioner submits that since they were appointed as civil sector officer, they are to be the Election Commission of India transfers which are made, that they are excluded from the transfer in terms of the guidelines issued by the by the memo number so and so dated. Under such circumstances, the present petition by to challenge the new transfer order dated 29/35. This court by order dated 15/3/2024 permitted the respondents to complete their instructions and directed both parties to maintain status quo. The status quo order has been extended from time to time. Whereas, the counsel for the respondents submit that pursuant to the orders being passed and the status quo order being issued, the petitioners have been relieved of their responsibilities as sector officers. And therefore, as on date, the very ground on which the writ petitioner has sealed the transfer order is not retained. So, counsel to the parties have been heard reading the writ petition of the you seen that the transfer order was issued on 25/2/2024. As on date, perhaps the guidelines of the ECI by the memo number so and so are not applicable to the petitioners, as the responsibilities of sector officer were imposed on the petition were conferred on the petitioner only on 29/2024. So, be that as it may, since there was a status quo order grant, petitioner remained in their original places of posting. It is also submitted by the council to the petitioner that not extending the status quo report, the petitioners were released. They were released.
Not matter, the released from the only election duties, my lord, not from the department. Because
After the,
after the debate, this court by order dated, your lordship, on page 90. 90 has stayed. Subsequently stayed for the transfer
status
order.
quo.
Yeah, subsequently stayed the transfer
No,
order.
no, initially there was a status quo order.
Yes, sir.
Yes.
Yes.
So pursuant to the status quo, you were released. You were sent to the, you were released from your places of posting.
No, that was challenged, my lord. Then that release order was stayed. Sorry, they have withheld, my lord, release order. That we have challenged. Then again later on, they have taken leave of this court to release us, my lord. Then this court granted relief on as per order dated page 90, my lord. 90.
90 of the writ petition.
Yes, writ petition. Oh, 90 is not, it is there in the order, my lord. In the order sheet, your lordship get. In the order sheet, you will get, your lordship will get 4/4/24. In the order sheet, 4/4/24.
He was released as sector officer.
No,
So that is challenged by way of a separate writ petition.
it's separate writ petition.
So you, you submitted that there was a violation of the status quo order.
Yes, violation of status quo order.
In respect of what?
In respect of the order passed by the honorable board in this case, my lord.
In respect of release as sector officers or release from your office?
No, sector officer.
In regard to your transfer,
Subsequently, the election commission authority had released the petitioner from have relieved the petitioner from the responsibilities of sector officer or zonal magistrate. Being aggrieved, the writ petitioner approached this court again and filed WPC number.
First, he filed the WPC 1855, challenging the first release order of 19/3/2023 or 24 order, which on which occasion that relief order was withdrawn, your honor. So this court decided that that matter has been become infructuous since the election commission has already withdrawn his relief order, your honor. Subsequently, this honorable court on 4/4/2024 has granted leave to the election commission,
No.
allowing us to he has filed a subsequent writ petition.
So, what is the number of the writ petition?
First writ petition was 1855, 1855.
1855 of 2024, where the release order. The order relieving the petition was put to challenge on the ground that the same is violative of the status quo order passed by the Supreme Court. Since on filing the writ petition, the election commission withheld the order relieving the petitioner from his responsibilities as sector officer.
Sector officer.
So, under such circumstances, the WPC was disposed of as the so, thereafter, coordinate bench by order dated 4/4/2024, while considering the matter, permitted the respondents with their instruction and extended the interim order passed by here. Had also granted leave to the election commission to release the petition from the election duties. Pursuant to the leave granted by this court on 4/4/2024, the order relieving the petitioner.
5/4/24.
Same order or different order?
Different order.
Separate order was issued relieving the petitioner from election by the order dated 5/5. 5/4/2024. The said order is again put to challenge by the writ petitioner by filing
WBC number
2202.
2202.
2202 of 2024. in which notice has been issued and the matter is pending before this. The very basis for challenge of the transfer order is that the guidelines, CI, that sector officers are to be excluded of the routine branch for election purposes have been violated. It no more a ground today in view of the leave being granted by the coordinator by the order dated 4/4/22 and release order granted by the order relieving the petition granted on 5/4/22. Under such circumstances, since the only ground for challenge is the CI and no other ground is heard, this court does not consider that the petition will require any further consideration at this stage. Accordingly, the same is disposed of as instructed. The authorities may consider reposting the petitioner after after the conclusion of the election work, if so advised. Writ petition accordingly stands disposed of, interim order dated so and so stands vacated. Pending ILs are also. That's all.
Yes.
Much obliged.
Okay. Yes.
I'm very sorry, Lordship, I was in court number 1.
He wants to dispose of the matter on terms of the order.
Lordship, after due verification,
Yes.
authority will decide, Lordship.
Yes. Where is that order?
Order at page 66, Your Lordship.
66.
11.
Relevant order.
66. We heard that it comes this. Particular order 66. Yes. Item number 6. Yes.
Highly obliged.
Yes. Who is filed the IA?
By the department, madam,
Where is the department?
elementary, madam.
Elementary education. Where is the elementary education? This IA has been filed by the state, vacating notification for the reach of the President 323, passed in WP 2.5. However, none represents the state. Pressing the IA to be listed.
Obliged.
Mr.
Sinan.
For the
Obliged. May date be petitioner is already retired, man.
Huh?
Petitioner is already retired from service, so no service benefit. Date may be fixed.
You have not filed the IA?
Obliged.
My lord, I have appeared for the Union of India as well, for item number 13. Petitioner on the last occasion also, he has not appeared. Regarding traveling allowances, my lord, regarding
Transport. Not appeared. None appears for the petitioner matter being court. Sir, Sharma appeared for court.
He's in item number 13, Lordship. I'm in item number.
Sir, I can have spoken for the government and for item number 13 and 14. You are here in 13.
I'm for 13.
And
I am in item 14 for BRTL, respondent number 6 to 7. R. Kakuti.
R. Kakuti appears for item 14 in BRT for BRT.
6 and 7.
6 and Order K 2004. For the Union of India. What interim order is there?
No.
Petitioner is not.
Perhaps Lordship last occasion also not there, perhaps Lordship. In any case, Lordship.
No,
I do
last order says respondents are not here.
No, perhaps.
14, item
Oh, in item number 14. We'll give them one more opportunity.
Last facility to the petitioner.
We'll give them one more.
Yes, yes.
Item 15.
Here the petitioner has not been appearing, my lord. It is a case regarding payment of area salary where the service period of the petitioner has.
One more opportunity.
Health department.
Health department. Please.
May I please, your lordship? Yes. Lordship, in this case, as per the last order, 12/6/2023, the respondent was supposed to file an affidavit saying the status of what has happened. Because as per my instruction, respondent number, all the, only 4 respondents have, only respondent number, with regard to respondent number 5, lordship, the case is pending. With regard to 1 to 4, they have paid from this petition.
Lordship, we were going to file our affidavit, otherwise, Lordship, those pertains to illegal, irregular appointments, subsequently they have been.
It is not covered by Supreme Court.
No,
No, Lordship, no, Lordship.
Stipendary teacher.
No, Lordship, they have been subsequently accommodated as teacher and teacher. Only in respect of petition number 1, he could not be accommodated because by the time he attained the age of superannuation. So we are going to file our affidavit, Lordship.
2017 matter.
But 2020, Lordship, in terms of the cabinet decision, these petitioners have been accommodated, Lordship.
Only 1 to 4, not 5. 1 to 4, not 5.
5 is retired.
No, retired,
No,
lordship.
petition number 1 retired, Lordship.
No. 5 retired only.
And
So petitioner number 5 may have retired.
we are going to bring on record, Lordship, by way of an
Let
affidavit.
them file an affidavit, then we will.
Lordship.
What is your prayer?
Also for area salary, lordship, from March 2012,
Working at?
assistant teacher, lordship.
But your appointment,
Illegal, irregular teacher.
No, lordship, that if that has been brought on record, I could have challenged it or would have taken any action against that. There's no affidavit from their effect.
We'll file 2 weeks time. 2 weeks time.
Let them say that it is illegal, then we will.
Element week further time.
Lordship. Except petition number 1.
They were appointed as tutors.
Tutor or teacher, some teachers, some
Tutor
tutor.
or teacher,
Lordship.
except retired.
In them.
Are required for export as such as claim the petitioner area channel area channel was as assistant.
With regard to that, petition number 5, lordship.
Huh?
Petition number 5 only.
What?
My prayer is in respect to petition number 5 only.
Why?
1 to 4, lordship, they have been accommodated in the year 2024.
We have only
One
given
to
some this.
four is not pressing.
No.
Because four have already been accommodated respective. Therefore, are pursuing the decision and they seek no relief. By 5 after.
Highly probable. Highly.
Item 70.
May I please, your lord. Lordship, the method is for non-payment of salary since the date of promotion, lordship. In this regard, lordship, the council has filed their affidavit, lordship, wherein stated that the promotion was in due process of law and it was followed by the approval from the principal secretary, lordship. Yet, lordship, I have not received my salary, lordship.
Yes.
My lord, the petitioner has not party, my lord, the Hills Area Department, my lord. The Hills Area Department is the main party. My lord. Yeah, they will approve. So they have to make Hills Area Department, Hills Area Development, my lord, as a respondent. My lord.
What is Hills Area?
My lord, Hills Area Department, my lord.
Why is it?
My lord, they are the competent authority, my lord.
Competent
They have to approve, my lord.
rendered services under.
No, we have communicated, my lord. We have now pending before the Hills Area Department, my lord.
Hills Area. Let's say
These
Hills
are,
Area.
even my lord, finance is not also not made as a party.
So Hills Area.
Hills Area Department and the finance, my lord.
What have you communicated?
But we have not
Yes, then.
approved, my lord. Page 38 or not. Page, my lord. 37, can you have a look, my lord?
Page?
37, my lord.
37.
This is an approval letter.
This is from social welfare.
My lord.
Social welfare. Then
Then, my lord, page 39. My lord.
yes, who's for the government?
Department, they have to make it a party, your lordship.
First, get the instructions what has happened in a letter sent on 21st March 2024. You hand over a copy. Hand it over a copy. You find out what is the status here. It is submitted by the hearing for the Mahasab.
2, 4, and 5.
Not Qatar. That the approvals of the legislation have been communicated and presently the matter is pending. Well, let's sanction the Hills Area Department. What do you call it? Demand. NCL.
NCS, sir. NCS autonomous command.
Yes, is it NCL or autonomous? Demand.
No, no, now, my lord, NCS. my lord. Formerly, it was called Dima.
The communicated dated 1st of March 2025.
2020?
First one.
That the Hills Area Department not related to part. We are recording your name. Right. Data. Data. Order path. By Hills Area Department. By using it. The furnished and put up in 3 working days. 2 working days. I will be listed after.
May I please, your lordship, matter may be passed on for the day, lordship.
Why?
So old matter, lordship, we don't know matter is in fractures or not, we just, instruction from, we need instruction from the petitioner, lordship.
Become,
Maybe become interest source, madam.
yes.
We have already released the salary, madam.
Where, do you have any documents?
Madam, man, I have a final affidavit, madam.
Where have you stated?
Please, my lord. Annexure A, madam. My affidavit. My affidavit, madam. Annexure A.
Annexure?
A.
10.
This is a certificate issued by the madam, executive engineer. This affidavit was filed on madam 28/18, madam.
No page number?
Page number, running page number.
Annexure?
Annexure A, madam.
Annexure A.
So this is a, madam, this is a certificate, madam, if you have not found it.
October 16 to June 17, you have been released.
Madam. And subsistence allowance, madam, July 17 to madam, September 20. Madam, this was long before madam 2018, madam. Subsequently, they may be filed, madam.
This has been released.
So we not in, we have no instruction, lordship.
Of course, he'll not have because he's lost interest, got his salary. He doesn't want to part with his salary with you.
Only, pass off for the day, today, lordship.
All right. List on Friday, 3rd.
Lordship.
It's submitted by the respondent council that the petition may have become structured and the prayer of the petitioner with regard to release of various salary of period of October 2016 to
June 2017.
June 2017, along with subsistence allowance for July 2017, from July 2017 to September 2017 release, and a certificate that is issued by the assistant executive PWD NC that it comes into the petitioner, pray for a date time. Mr. Gora 4.
Respondent 1.
Open for.
Madam, I'm for the OSP. Respond number 1.
Huh?
I'm for 1.
You are for 1.
I'm for.
Who is for, where is Mr. Bora?
1.
Only for 1.
1.
So you, between the two of you, will decide who.
He will appear.
Mr. A.
Because earlier we used to appear that
One.
way.
Deep level.
Right. Yes.
My lord, now my lord, Secretary Education Elementary filed their affidavit. Copy have been served to me, my lord. File on 13/3.
Yes.
My lord, the case for non-payment of salary, my lord.
Your pleadings are complete.
Pleading complete.
You have filed your reply.
Yes, ma'am.
We'll keep it for admission hearing.
Yes, ma'am.
Matter be listed for admission hearing.
After 1 week, my lord.
After 1 week, but it seems, date available. On 16 May. MS has sworn appears for the secondary.
Elementary, lordship.
Elementary.
Elementary.
22.
Lordship, it also needed time, lordship. So it's a arrear salary, lordship.
Area salary.
Malad, it is subject to the outcome of the judicial proceedings, Malad. There are two court proceedings that are still pending against him, Malad. At page 4 and 5, para 3.
Yeah.
Page 4 and para My lord, para 3 and para 3 of this writ petition, my lord. GR case number 1624 of 2016 and GR case number 2206 of 2016.
So what is the prayer here?
He's seeking all the arrears that are due to him.
Arrears.
Arrears.
Why haven't you paid?
Considering the fact that the proceedings are still pending.
No, but you can't hold on like that unless you initiate any departmental proceeding. He's asking for his salary.
Well, FR 54 stays otherwise. FR. He was suspended initially. He was suspended initially. Post that the suspension was revoked. Page 106 of the FR rules.
Yes, what does it say?
Where suspension is revoked pending finalization of
FR 54.
54B. Clause 6 at page 106.
Yes.
Where suspension is revoked pending finalization of the disciplinary or court proceedings. So right now the court proceedings are still pending, madam. Any order passed under sub rule 1 before the conclusion of the proceedings against the government servant shall be reviewed on its own motion after the conclusion of the proceedings by the authority mentioned in sub rule 2. You shall make an order according to the provisions of sub rule 3 or 5 as the case.
Suspension is revoked.
Suspension has been revoked, but it is pending finalization of the court proceedings. Both of them are currently pending. So let the court
proceedings will mean what, at what stage is it pending?
Appearance.
Yes. Cognizance has been taken.
Cognizance has been taken. Check the status in the Hailakandi District Court website. So it's appearance. And the petitioner would be in a better position to state.
No, 6 does not necessarily give you the power to release only upon conclusion by review.
Let's see, for example,
6 says 6 has a reference to sub rule 1.
1.
Sub rule 1 says
Shall consider and make a specific order
No,
regarding the pay and allowances to be paid. So in case, my lord, if it is paid now and later on
no,
he is
you
convicted,
you read sub rule 6 again.
where suspension is revoked pending finalization of the disciplinary or court proceeding, any order passed under sub rule 1 before the conclusion of the proceeding against the government servant shall be reviewed on its own motion after the conclusion of the proceedings by the authority mentioned in sub rule 2 who shall make an order according to the provisions of sub-rule 3 or 5.
So if you revoke, you release the salary. But after conclusion of the court proceeding, on your own motion, you are entitled to review it, assuming there is a punishment.
But that will create a hassle here because in pension rules, rule 21 and 22 of the pension
That
rules,
is a different.
that talks about only pension. However, my lord, if this amount is released today, say for example, and later on he's found convicted,
You'll have to recover it.
so that will
He's a
be-
government servant. He's entitled to pension.
my lord, as on date, he is entitled to provision pension as per rule 22.
The interpretation which we are seeking to offer is actually the reverse. You are saying that since there is a proceeding pending, no release, we review it after the conclusion. That is what you're trying.
My lord, my lord.
But perhaps the reverse, which is acceptable for reading clause 6, that you release as per sub-rule 1. But your power for review at your own motion is there after conclusion. Meaning, you can review it after conclusion of the proceeding. Depending on what is the outcome of the proceeding. But as on date, no suspension, no proceeding. So what basis are you holding?
That's true, but that will involve another round of litigation on the part of the state if in case he is not exonerated and he is found guilty.
But then
So
you must have a source of power there.
get back to the on that particular point. I'll find out any other
Perhaps it's not the interpretation
as far as this particular.
as far as 54B1, 51, 54B6. Perhaps not. Because 6 is subject to 1.
Yes.
1, there are no right in it. 1 doesn't say subject to 6. 1
6 is subject to 1.
To be suspended or reinstated or could have been so reinstated. Okay. But for the retirement, on superannuation, while under suspension, already completed. He is retired now.
He's retired.
Repeat. Or you take reports to 21, 22.
My lord, for that recourse, my lord, that is pending. The judicial proceedings are still pending. So as on date, rule 20.
But that is not left to the authority. Only the governor.
My lord, but for that is only confined to the pension part, withholding of only the pension, not of the amount that is.
This is about salary.
Yes. That's why I was.
Perhaps your interpretation that you're trying to give from FR 54 may not be.
Well, because the point is that sometimes what happens, the particular individual retires, but the disciplinary proceedings are still pending. Under such circumstances, my lord, the release of any allowance or salary arrears is subject to the outcome of the disciplinary proceedings.
Right. But you have revoked it.
My lord, the disciplinary proceedings were never initiated in fact. The
But
suspension was revoked.
what happened to the DP?
Well, the DP was never initiated apparently. I have to take instructions on that, but I don't have any options on that aspect. I'll have to, give me a week's time, get back on that issue.
Might have been listed after 1 week. And if the standing council PNR. Right? 4. Pay area. Again after. Yes, Mr.
May I please, my lord, here in this case, my lord, petitioner paying for arrear salary as well as pensionary benefits. Petitioner already retired from the service, my lord, on 2018, my lord.
Pleadings are
28
complete.
pleadings already completed, my lord. Your lordship may have heard the matter in any day, my lord.
Hearing. Sorry, on 16.
Obliged.
Obliged.
Should this matter become infructuous, my lord, the petitioner challenged the
Where is
suspension
the
order.
petitioner?
Earlier, BJ Talukdar sir was the petitioner, now he is the government advocate. This matter become infructuous, we have reinstated the person, my lord.
Give us a copy.
My lord. Dada. And presently he is applying for VRS, the petitioner. Trust if I can. F1 Dada.
Here, the challenge is only to the suspension.
Suspension. So we have reinstated, the matter become infructuous. And presently he is applying for VRS. He is now senior assistant in the office of the DTO Dhubri.
It is submitted by the learned counsel for the respondent.
That's the
That's-
transport department.
For the transport department. That the petition, the challenge made in the writ petition was with regard to suspension. Stopped by order dated 22 February 2024.
He has applied for VRS. Earlier we have reinstated him,
Oh,
the other.
by order dated 19 October 2020. Petitioner suspension was revoked and he was reinstated in service. I think we had that apart, by application dated 22nd of February 2024, the petitioner has applied for retirement with effect from 1st of June 2020. It is submitted that since the suspension has already been revoked and no further prayer made in the none appears for the restriction. Having heard an announcement, standing out transport department reading the available report, it seems that the sole ground for challenge the restriction is the sole ground for challenge the restriction is for revocation of the suspension order and reinstating civil service. Same prayer the by order dated 19 October 2020, petitioner's suspension has been revoked and is in reinstated service. There is no other prayer made in the petition to result later that dismissed as a practice interim orders with any stand for
Deeply obliged. Trustee may keep my internal particular.
the instructions given to the court are kept as a part of the
I'm deeply obliged, my lord.
Lordship, within this matter, Lordship, I have obtained instruction, Lordship. Lordship, may allow me some time to file my affidavit. Lordship.
Yes.
21 metal, time frame may be fixed, Lordship. Their affidavit is also important, Lordship, in dispose of the matter.
There is standing counsel higher education. Like to file an affidavit. It prays for 3 weeks time. Learned counsel for the petitioner does not take to the prayer made or listed on counsel for higher education. File the affidavit positively before the next day.
Highly obliged.
Interim order, lordship, 28/10/21.
Interim order dated
21/10, 28/10/2021.
28/10/2021.
Highly obliged.
Obliged.
Sir, there is a proceeding going on, my lord. The inquiry, my lord, is almost complete, my lord. The officer will submit the report shortly, my lord. That is the status. He has participated, cross examination with our, my lord. The report is to be submitted.
No, what is his challenge here?
My lord, he
What
was,
is his challenge?
my lord, he was, my lord, not allowed to attend the school and his salary was upheld, my lord. That
Held
was
up.
his prayer, my lord. He was to allowed because he was,
Release of salary.
yes, my lord, 10 years salary there and he was not allowed to attend, my lord, because he was unauthorized absent due to medical reason, my lord.
So they conducted one inquiry.
You're filing.
But I will place the, my lord, inquiry report and all, my lord, moment it is submitted.
My lord, there was an order of January, my lord, 24, my lord.
Yeah.
Kindly, my lord, produce the January order, my lord. Yeah, the direction for filing the affidavit, my lord. 10th of January.
Along with the report, I will submit it, my lord. Otherwise, my lord, I will have to submit again, my lord.
Heard Mr. M.J. Kadir.
SSA, my lord.
SSA. Submit that the inquiry is conducted against the petitioner is in the final stage.
Lord.
And the report is likely to be submitted again by the officer on any date. Thereafter, necessary order to be passed by the submits that. Once the report is submitted, say to be placed before the court. Placed for
My lord,
2 weeks.
2 weeks, sir.
my lord, an affidavit may be submitted, my lord, because we will get the copies, my lord, if affidavit is submitted, my lord.
2 weeks.
But if the inquiry report is submitted, it will be furnished to the petitioner, my lord.
So the respondents are also permitted to file their affidavit. If so,
Problem.
it's again on, you want a date?
Yes, my lord.
27.
27/5.
May.
27.
May I please, your lordship. Well, the respondent required to file an affidavit, lordship.
Yes, respondent.
Hello.
Lordship, may kindly come to page number 24 of the requisition, my lord. This is the order, my lord, by which petitioner was reinstated in his service, my lord. Thereafter, he is continuing, my lord. Now, in this present requisition, my lord, he is praying for the arrear salary, my lord. That may be outcome of the DP is still pending, my lord. Outcome of the DP, my lord.
When was it initiated?
DP already initiated, my lord.
No, not DP.
When?
Initiated.
When?
Well, no DP was started. Yeah. Although, lordship, I was suspended with effect from 26/7/2011, lordship, and reinstated on 5/10/2020, lord. And since these lordship 10 years, lordship, that only subsistence along, although after interference of this honorable court.
First so cause notice with the statement of allegation was issued on 6 December 2022, my lord.
Now, why for 2 years the DP has not been completed?
My lord, regarding the DP, my lord, I'll take instruction, my lord. At what stage it is, my lord?
What do you mean, what stage? How long does the DP take?
My lord, Lordship may grant 2 weeks time, my lord. I'll
What
take
2 weeks?
proper instruction.
What 2 weeks? You find out why,
My lord,
what stage the DP is pending and why?
my lord. And one criminal case is also pending against him. my
Criminal
lord.
case is a different issue.
Yes,
But
yes.
if you have initiated a DP,
My lord,
that at what stage, what is the, why the DP should continue for 2 years?
my lord.
It is submitted by the standing council. PNR, that the departmental proceeding decides the criminal proceeding is pending in respect of the writ. However, it's not posted the status of the department proceeding waits for 2 weeks further time. Sir,
NH board we have.
NH board. You are now, you are under suspension, no?
No, I am continuing, Lordship, after
You
order
are
of
paying
this.
for your area, sir.
Area salary, Lordship, as well as Lordship fixation of pay, Lordship, because in the year 2011, the salary which was given to me, Lordship, that was given to me now, Lordship.
Let the matter be decided again on 27th May.
Well, I know.
Mr. Borough for
Press number 2, you.
I'll apply, madam.
Yeah, well, I'm appearing for the, we are filing our affidavit today.
which respondent?
All the respondents.
Sir, in that hearing on behalf of all the respondents, filing an affidavit during the course of the day.
No, already filed, man. Copy is served.
Lordship, we have received the copy, but we would like some time to file an affidavit.
MS
MSS Ahmed.
S. Ahmed. Commissioner submits that she'd like, copies have been received and she'd like to respond by filing reply affidavit. If the dates were right, they were raised for 3 weeks. Time. Is the matter after 3 weeks. That this is for what?
Lordship, this is for his, Lordship, it is
What
for
is the
the
issue here, Mr. Nath?
post-retirement service.
Yes, they are seeking some leave encashment, gratuity and all that. Post retirement.
Yes. No, I am asking you because I have to ascertain what is the subject matter.
Actually.
Yes. Yes.
Lordship, regarding item number 33, Lordship. Lordship, I have gone through the connected case, Lordship, orders of connected case, and I have found that, Lordship, those cases are not connected with my case, Lordship. My case is separate for only, Lordship, because the order mentioned 85086, Lordship, that issue is different, Lordship. My issue is different,
Wait till take up your issue.
Lordship.
Your item is what? 33.
33, Lordship.
You are praying for what?
My praying, Lordship, my SLC has rejected my prayer, Lordship, so DLC considered my, and immediately, Lordship, after getting a copy of rejection, Lordship, we have approved this code. That is at page, Lordship, 56.
You are praying for compassionate appointment.
Lordship.
And what are the other repeated? Same.
The grounds, Lordship, grounds of Lordship.
Rounds may be different.
Yes.
You are praying for compassionate.
Compassion appointment issue, but Lordship, grounds are different.
Appointment and compassion. Yes. What is to be done?
In my case, Lordship, I have found the connected order, Lordship, orders of connected cases, and those orders are different, Lordship. They have, Lordship, the case are, Lordship, regarding delay. The SLC rejected, Lordship, prior to 5 years ago, Lordship, and they have subsequently come. And my case is, Lordship, we have come freshly, Lordship, immediately after getting the order in 2023 itself.
It's okay, but pertaining to compassionate appointment.
Yes, sir.
Yes, affidavits have been exchanged.
My lord, in fact, Lordship may kindly have a look at the last order passed on 19th of January. There, your Lordship was pleased to mention that we have filed our affidavit and they,
So in which matter you are referring?
58, my lord.
58.
Yes. 58. Common order. That possibly that's a common order. 58, my lord, Lordship fine. It was a
WPC 5086 of 22.
5383.
Where is that report?
That we have already filed, my lord.
The report, my lord, lordship will find
Connect to the affidavit.
page 58, running page 58. my lord.
58.
My lord.
This is the report by the committee.
My lord.
Now, what is under challenge, this report? No.
The report is not under challenge. They have, in individual cases, they have come against rejection order, etc., etc. Now,
What do you say about this report?
Lord, may I, because my item is 64, my lord, in that report part, my lord, it just make- as far as the report part is concerned, my lord, that is in my humble submission, a verbatim reproduction of all the orders passed previously. So there is nothing new in that report. It's a verbatim reproduction that this person has been rejected for so and so ground. That was in all the similar cases, all the rejection order that has been reiterated in that report. So in my humble submission, my lord, that
What is the professional appointment, the guidelines, the judgments are all there.
All.
And more particularly that
So Devabrata Tiwari, what is?
1/6/2015 guidelines are there. How
Yes.
it's like- Now, then each case will have to be decided.
Exactly. Exactly. In fact, if my fellow counsels may submit, my lord, he submitted, he submitted that his case is in fact, we go on that. In fact, instead of clubbing it together,
No, clubbing it is because the respondents will have only one argument or common argument.
That's all, my lord. Fine.
Therefore, to that extent, the clubbing is necessary. But to examine your claim,
Yeah.
if the claims are different,
Yes.
ground, have to be examined.
Exactly.
Lordship is correct, meta may be club, but meta may be taken up and considered in individual way. Lordship, in my case, Lordship, item number 35. They have relooked at my claim and give observation in favor of the petitioner. Because they have admitted their guilt that my rejection was improper. So in that case, Lordship can pass an issue direction to case, consider my case by special SLC, which they have admitted in his report, page 64, Lordship.
my lordship,
63 and 64.
lordship, in fact, on the last occasion, when your lordship passed the order that some of them wanted to file a rejoinder. If they file, it is all right. If they do not file, lordship may keep it for hearing. In the hearing, my lord, individually, lordship may case hear the matters and dispose of one by one.
Page 63, Lordship.
If the facts are differing, then
Page
individual
63,
case may be disposed
petition
of.
number 8119/7, Adoy Mahanta of the state of Assam. So my case was rejected that it was filed beyond 3 months.
We'll hear it. You complete the pleadings if anyone wants to complete the pleading. Otherwise, we'll proceed to hearing.
Yes, yes.
So far as my case, there is no one required to file any reply. So my case, the
Whatever
pleading is
we are giving
complete.
reply, we are giving liberty to all the council.
Okay.
If you think that you need something to file a reply or anything, you file it. Otherwise, we have the cases listed on 28th of May.
I hope other councils agree to
Subject to
We have already filed.
Mr. Mazumdar, 28th of May.
Madam, that's it.
No, last date to decision of 29
They are not taking time, we are giving time. We are giving
28?
time to consolidate the hearings and giving an opportunity to complete your pleading.
28th of May, it's all right.
28th May.
Can it be 30?
Why?
I have some technical things.
We'll take it up on 30, your matter. You identify it.
Let it start from 28th.
Let it start on 28th.
Yes.
Lordship may make it clear that in the meantime, if anybody, any of the petitioners desire to file the rejoinder, they will file, otherwise from 20 it will start.
Learned counsel. For the- Give the names, give your names to the court master. The difference.
আমার পরিবার আমি করি
Are fine. Area ground. In direction of the partner. Consider the claim professional.
আমার লগে যখন বুঝলো না
Your case would be 58.
No, I'll be arguing on behalf of the state in on the all the cases.
You have filed only one affidavit.
One affidavit is cover, my lord.
In 58.
My lord.
Perhaps that may be the lead case.
Let's file an affidavit. Petition in item number 58. If the yes, ma'am. So internal additional submits that this affidavit can be relied on for the purposes of all the other cases as the ground are similar.
Oh,
No separate the respondents, the writ petitioner are at liberty to file their reply affidavit. In some of the writ petitions, the reply affidavit has already been filed. In some, the same are yet to be filed. So, under such circumstances, it is agreed by the council. The matters are listed for hearing on 28th of May. So, the WPC number 5086. Who is appearing in for the petitioner in 5086?
No, I think Mr. Chitni is there.
Mr. B. Chitri is there. In fact, that matter is not on the board today, my lord. Huh? 58. Oh, okay. 58 when he's there.
Will be taken up as a legal as the affidavit has been stated, affidavit of the state has been stated to have been filed at the same time. So it is made clear that the petitioners are at liberty to complete their meeting by filing additional affidavit / reply affidavit in their respective writ petition prior to 28th of May. This registry to this recording. Registry will reflect the names of all council of petitioners as well as the
Copy of your affidavit may be also provided for common affidavit.
Who's the affidavit? That chapter is over. After they got the affidavit, they have started filing their rejoinder. Now you are saying.
Reply was in my case, I didn't have it.
If you have not got, you will get it.
Yes, you should be able.
The learned counsels for the petitioners are requested to are at liberty to furnish their respective emails.
Yes.
To the office of the additional AG Assam.
But he has already done it.
Already
Which department is it?
Which department?
My lord, I am appearing for my lord government. I'm assisting
Lordship may say that they will
The
provide
office-
the email ID
the
to Mr.
office
Dhar.
Of
Dhar.
the government advocate, Mr. R. Kaur.
Yes.
And in which case the soft copies of the affidavit
Yes.
filed in WPC 5086 along with all enclosures be furnished all the councils. This exercise be completed by 6th of May 2024. Please record.
Public.
Public.
But so far as the names of the councils are concerned, those who are present today, or it will go as per the list?
Whoever has appeared, the name are to be recorded, or if you don't want, we'll not record.
No, I'll fill it.
May please. But matter relates to my lord revocation of suspension or my lord. So my lord notice has been issued, my lord. and
Affidavit not filed.
Not filed, my lord. Last 3 occasions, my lord.
Yes, who's for the GMC? This is GMC.
Yes.
Affidavit not filed.
Affidavit not filed, Lord.
So do you intend to file an affidavit?
Lordship, I have to file, Lord. Otherwise, Lordship, in this case, so cause has already been issued within 90 days period. Thereafter, a regional order was passed extending the suspension of the petitioner.
Bring it on record.
And what I signed that return order.
Why don't you bring it on record?
That is already there in the petition itself, it is there, Lord. I will only place the status of the case. Lordship, I will file one affidavit.
No, next that may be picked, and and then for the police.
Go ahead, go in. Mr. A. Sharma appeared for the petitioner, Mr. P. Nayak. Is granted 2 weeks. 2 weeks.
Lordship, kindly make it 3 weeks, Lord.
3 weeks further time. Complete his instructions and place it before the court. Respondents are at liberty to file their affidavit. It's the matter after 3. You want a fixed date?
Yes, my lord.
We'll have it on 3rd of June.
On the 4th of June,
Fourth.
No, 28th of May, my lord, 28th.
28.
Yes, my lord. But if possible, my lord.
No, see, unless we are ready for hearing, we
Yes,
don't
my
want to
lord.
fix it
Otherwise,
on
yes,
a hearing.
yes, yes.
So let
Most
us have
on
it
them.
on- we can have it on 29th.
Yes, sir.
29 May.
Same, 73. Yes, sir.
70, 71 to 3.
Five.
75, 74.
Lordship, in this matter, we have received instruction, Lordship,
Which matter?
75, Lordship.
75, somebody has already paid for time.
No, we are not aware, Lordship. 74.
In the morning. Huh? Oh, 74. Oh, I'm sorry. Yes.
Lordship, in this matter, family pension has already been sanctioned in 2007, Lordship. And once it is finalized, Lordship, thereafter the department has no role in this matter, Lordship. If they have anything grievance, Lordship, they have to contact the Treasury Office regarding this, Lordship, regarding enhancement, revision, all this, Lordship.
Khan appears for the.
My lord.
You're appearing? Yes. Family pension has been sanctioned?
No, family pension is sanctioned, my lord, but
Waiting for
that was not revised, my lord.
Huh?
Petitioner's pension was not revised, my lord, as per OM, my lord.
It is to be revised by whom?
Yes, my lord.
Lordship, instruction has been received from my accountant general.
Page 17, my lord.
What
This is the-
effect? What does it say?
It has been said that Lordship, the family pension has been revised. It was earlier fixed at 4,550 and now it has been revised to 6,780. Lordship, my peruse.
No, my lord, minimum, my lord, here, my lord, minimum family pension should be, my lord. I can't come to page 17, my lord.
Yes.
Division of family pension, my lord.
Yes.
No, my lord, the.
Yes.
I am coming, my lord, just. It has to be. Factory. Here, my lord, revision of pension number 3, my lord. Revision of pension and family pension. The pension oblique family pension of the existing pensioner, family pensioners that is pre-1/4/2016. Pensioners, family pensioners shall be revised with effect from 1/4/2016 in the following manner. The revised basic pension, family pension with a 1/4/2016 of the pensioner, family pensioner who were drawing pension, family pension on 31/3/2016 under the Assam Service Pension Rules as amended shall be fixed by multiplying the existing pension family pension by factor of 2.48 million. And my lord, family pension earlier drawing was my lord 4,550 my lord. Ultimately, it is multiplied by my lord 3 point my lord. 2.48 my lord. It will be nearly 12,000 my lord.
You go through this, show him that instruction. You don't have any other copy? Only one copy?
Lordship, I will.
We'll take it up after a while. Just go through the instruction.
Well,
My lord, affidavit is required, my lord. It's, my lord, terminated after inquiry, my lord.
But similar matters are pending. My lord may either tag it together or may not direct.
It is submitted that instructions are still awaited by the current standing council hearing for TNRD.
TNRD.
Further submit that several similar matters are pending. This matter may be listed along with it.
4707 of 2020.
What is that? 47?
07 of 2023.
4707 of
23 my lord.
2023. And other?
And
Other numbers you have?
I'll prepare a list. my lord.
Give it to the court master. Be listed along with 4707 of 2020. The respondents are permitted 3 weeks time to find their affidavit. Mr. M.J. Katir appears to be just after 3 weeks, along with PP Mr. D. Bora. appears
Number
before
3.
respondent number. Yes.
In item number 7, Your Lordship, in item number 77, I am seeking a short accommodation. Mr. T.C. Sutia, he appeared in last occasion. He is undergoing eye operation. So the brief is with him, Your Lordship. May he prays that the matter will listen after 10th of May, Your Lordship.
It is submitted by Mr. D. Bora that the council trustee is indisposed. Raised that is after 2 weeks.
After 2 weeks.
That I don't think that is based after
Only the date may be fixed.
22nd.
Highly obliged.
Because in this case, the fact, I want a short accommodation. Because the facts involved in this case is regarding the second wife and the children of the second wife. Now the fact, admittedly, Lordship, the second wife is not entitled. Now, as per the Hindus law, under section 16, even if the second wife, the second marriage is satisfied, the children are entitled are legitimate. That is some law, and law. Your Lordship is well aware of the judgment of the Ramesh Sri Devi, and by this honorable court in Justice, my Lord Justice Biplab Sharma's judgment is offered. So on this point, I will try to.
So you are entitled. What is there to argue? You are how many petitioners?
There are
3 petitioners.
no. As on today, there are 2 petitioners.
2 and 3.
As on today,
Petitioner 2 and 3.
petitioner number 1 is the wife. Petitioner number 2, by last date order, she has already got married. So I'm not pressing upon her, and by that I've made submission. Petitioner number 3 is an unmarried daughter.
So one and, so only three.
2 are left. Only 3 is left. Only the petitioner number 3 is
Three. One is not entitled.
One is not an uncle. Admittedly, there is subtle law that
Two
second wife is
also not entitled now.
the 2 is not entitled in view of her marriage.
Only three.
3 is entitled, and admittedly, he along with respondent number 10.
She is the first wife.
She is the first one, and I'm not denying that. That is
There are no children of the first wife.
no. There is no children of the first wife. And petitioner number 1 is the second wife. There are 2 children.
Now, who was supposed to file the affidavit? Joint affidavit?
Lordship, there was talk of this one settlement. Ultimately, they did not approach us, nor we did not approach them.
No, now, who's for the pension department? Or what department is this?
It is, my lord, it is APSC.
Huh?
The deceased was an employee of APSC.
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 You are representing whom?
I am representing the first group.
First wife. So, under law, the children of second marriage are entitled.
My lord, so far as the third petitioner number 3,
She is not entitled.
He is-
Petitioner 3, yes.
petitioner number 3, she is also not entitled because she is, number 1, she is adult, measure. Furthermore, she is an advocate, practicing advocate, she is not dependent.
No.
In view of that, those facts have been suppressed.
I
And the lordship, the Honorable Apex Court has the very specifically mentioned that if the read petitioner, they have suppressed and concealed the material facts, then the read petition must go. And she is an advocate, practicing advocate of this High Court. How she is dependent?
I'm just that will require full-length hearing, Lordship. That means I will satisfy your Lordship. Lordship, so far my learned friend says that he is not dependent. This is the notification of the government of Assam
Okay.
regarding unmarried daughters, unmarried dependent daughters. Now, your Lordship will interpret.
You will have to show that you are dependent.
Yes.
But if you are practicing, you are not
No, no, Lordship, practicing just for 1 year doesn't make that I'm fully independent.
Have you surrendered your license?
Yes, I'll file additional affidavit to that effect, Lordship.
You don't want to practice, you want to live on the bench?
No. Dependent, and what is the notion of dependent? She must be fully established to maintain herself. Now, when she is practicing just for 1 year as a junior advocate, whether she is fully dependent to maintain herself.
No, that is one issue.
Yes.
The rules are very clear.
Yes.
You have to be
No, Lordship, the question of dependent has been summarized by the Honorable Apex Court in very many things. What is the notion of dependent? It doesn't mean that simply saying that I am practicing for 1 year. It doesn't mean that I am independent to.
So the concept of dependent.
The concept of Lordship will interpret the concept of dependency.
No, you have no other means to sustain yourself.
Yes.
You are dependent on that either because of your age or because of the peculiar.
Age is no bar, Lordship. After amendment of this one, age is no bar.
No, age is no bar, provided you are dependent.
Yes.
So therefore, dependency will have to be understood. Facts and circumstances.
Facts and circumstances the case.
So for somebody, let us say, who has some physical disability or in a very remote area, staying alone, no means to survive, or is one aspect considered dependent.
Lordship.
And for somebody who has a means to sustain, but would not like to exercise that, whether she would be considered.
That will satisfy your Lordship. That matter will fix for hearing. That will take some time. Because,
May not take time.
yes. And if necessary, I will file affidavit to that effect. With
My lord, so far as this, if the lordship kindly peruse their page number 16 of the writ petition and clause C. Here they have categorically mentioned page number 16, Roman 2 C.
So that has been modified.
This is their writ petition.
No, that was
I'm
then.
not denying.
No,
I'm
that
not
was
denying.
then. But now I think the rule has been changed.
Yeah.
You have
I've
to be
given
an
you-
unmarried daughter, but you have to
Unmarried-
give a certificate of non-marriage and non-employed, unemployed.
Now the rule is that lordship unmarried dependent daughter. The age is no board.
Non-marriage and non-employment certificate. And then you'll have to satisfy what is employment. What is employment, what is dependency.
What is dependency lordship? I have tried to satisfy your lordship. That on these points, the Honorable Apex Court has given various category of decisions on the question of dependency. That has been.
You say an advocate is dependent, you could cast a very.
No, lordship.
impression.
The tenure of her practice, your lordship will kindly say.
When can we fix it for you?
My lord, my position is very, very precarious because I am exclusively dependent on the income of my husband.
No, there is no denial of about your
No,
income. The only
the,
question is
because of
whether-
this,
The question is whether a portion of the pension is to be apportioned. That's all.
there is,
Your claim to pension is undenied.
my lord,
You'll get it. But whether a portion of that is to be apportioned is claim.
then
That's
the
the only issue.
date may kindly be given very
You tell us what date.
within this month, my lord, I pray that let it be on this thing 10th.
No, lordship.
10.
10th
10
of May.
would not be
No,
possible.
Then let it be preponed
We
to
can have it on 16. 16th of May.
I'm having some.
Be on 17th.
No, you want a hearing, so it has to be on a hearing day.
Can it be on 23rd, lordship?
16th, let it be.
23rd is a holiday.
23rd is holiday. Yes.
16th, let it be, my lord.
16th, your colleague has some problem.
Or can it be on 21st? It is Tuesday, hearing day.
21st, their dockets are filled up, but we can keep it.
21st.
21st?
21st.
Based on 21st.
Deeply approved.
Obliged, lordship.
For hearing. For hearing. The rule has been issued here.
No, it is for admission.
Admission here.
Admission, it is, let the rule be issued, lordship.
For
Okay.
admission here.
Okay, good. Follow.
Your lordship,
Also section is there. Last occasion, my lord, notice was, my lord, issued. And accordingly, they have taken steps, my lord, but a report yet to be.
Office note 26 April, your lordship.
Acceptance notice. But none appears.
None appears.
Then what is to be done? Are we to appoint an amicus?
Yes, it does. Amicus or legal aid council.
The
Total custody 8 months.
although notices were served on the respondent. Number 2. And office note reflects that it has been accepted. Since this has been accepted and a copy thereof has been received by the registry. However, none represents the respondent. 2. Considering the fact that the petitioner is still in custody. Is in custody.
Custody for 8 months, 24 days, 268
Custody.
days.
Let the amicus curiae be appointed by the registry.
Option A, and stomach after.
Okay, we'll appoint someone. We'll
Yes,
find out either Michael Curie or Legal Aid Company.
Yes.
Fine. This does not differentiate between has to be listed again on 28.
May I
or
pay
earlier.
for a thought that your lordship?
Make us a copy, sir, reasonable, man.
15
15 May.
Right.
Copy, copy the,
Hey.
the case report be furnished on the Michael. All right.
Yes.
Mr. If
Right.
Finally, the Peter matter next to which matter.
Huh? You have seen that, where is that?
Yes, ma'am.
Ah,
Just I have to open the instruction as to there to 1/4/2016. What was the statement was doing, my lord?
whatever it was, they indicated that it is at the
That is
rate
why,
that you want.
my lord, ultimately statement will provide something, my lord. That is why, my lord, just because the office member of food works, my lord, for the previous advice, my lord, 1/4/2016.
It is written there and that the multiplier is also mentioned.
Yes, my lord, they have calculated me rightly, but I want to know, my lord, for my petitioner, my lord, what was the pension he was drawing before 1/4/2016, my
You
lord.
submitted that
Then he has to
the
consult the treasury officer, lordship,
the
concerned treasury office.
petitioner has been settled by the department and there is no further claim. Right. Mr. Hassan, learned, as Hope, learned counsel for the petitioner, however, that he granted a week's time to complete the construction. Again on 17th,
Mine.
75.
Mine. Oblige.
Can I take my instruction, lord? Take it. Oblige, your lordship.
Yes.
My lord, these cases are analogous in one aspect, whether Hindi is a language teacher or not. Over here, what happened, my lord, during the time of provincialization, when the district scrutiny committee sent this recommendation, in the recommendation sent my, though I am a Hindi teacher, when all the petitioners, my lord, in this series, though I sent my name was sent as an additional teacher instead of a language teacher. But then this department came up with a affidavit in the earlier proceeding that I have annexed in this writ petition, if your lordship please to see. Annexure 10 in my lord WPC 6277. WPC 6277, my lord. Item 83.
Six two seven.
The 83 item to the one. 83.
Lordship, before starting, your lordship, in last occasion, your lordship, the government was supposed to file affidavit. I don't know whether they have filed any affidavit or not.
You don't know, you have to see the court report. See it and tell us.
Let the
Item number 79, there is an affidavit filed, lordship. Otherwise, in other items, lordship,
Perhaps we need to file affidavit because the status and fact.
The issue is one and the same.
Same.
Issue is same. One affidavit.
And I think my friend on last occasion relied on this affidavit, which I have pointed out before my lord. My lord, page, annexure 10, page 55. Yes, my lord. That is the Director of Elementary Education's file. Yes, my lord. My lord, now would your lordship be pleased to see 58, paragraph 6, my lord.
Yes.
My lord got it. That in view of the above, my lord, earlier this, the 3 posts and all this have been said. In view of the above, it is stated that all the languages, including Hindi, which are taught in an UP school, have been recognized as languages within the meaning of section 3111 of the Act of 2017, and recommendation has been made by the District Scrutiny Committee for one language teacher for provincialization as teacher or tutor, as the case may be, from amongst all the language teachers, considering their other eligibility criteria as provided in the Act of 2017.
What does para 5 say?
Well, para 5, that in the said structure of teacher in upper primary school, the headmaster as well as assistant teacher were mainly to teach Assamese and English language, as no specific qualification is required to teach English and Assamese language. But specific qualification is required for the post of Hindi teacher and Arabic teacher to teach Hindi and Arabic language. However, as per section 3111 of the Act of 2017, there is a limitation of 3 teachers in UP school, each science and mathematics, social studies, C languages. And as per section 13(6) of the Act of 2017, the District Scrutiny Committee recommended one language teacher who qualified as per all other criteria laid down in the Act from each UP school, out of all language teachers working in the recognized UP school.
What is your qualification?
My qualification is a Hindi teacher, my lord. It is there. Over there, I have been shown as an additional teacher. That is the reason though I am senior, I have been dropped. Now, if you're...
There must be other Hindi teachers.
No, I'm the only one. Now, your lordship may come to page 51. In the earlier proceeding, I was asked to file an appeal. My lord, whether my lord has seen this tabulation, my lord. The third, Muhammad Rafi Mullah, who was provincialized, but his date of appointment is 2005. Kitish Chandra Rava, that is the petitioner, my lord, before my lord, additional teacher he has been shown. He is a Hindi teacher and his date of appointment is 2003. My lord, our appeal was only on the ground that we were wrongly shown as additional teacher. Now, after the appeal, the order which is impugned, that is in page 53, my lord.
Yes.
Would your lordship be pleased to see the last paragraph, my lord? Earlier, they have said everything about the position and about the joining. In view of the above, considering the enrollment position of the school, the claim of the petitioner for provincialization of service as additional teacher of so-and-so school hereby rejected. Even the appellate authority.
Come to the paragraph before that.
Subsequently, the proposal was placed before SLSC as well as the Joint Committee for recommendation, and both the committees rejected the proposal for provincialization of services of Kitish Chandra Rava as additional teacher. I was not appointed as additional teacher, nor I am an additional teacher. I am a Hindi language teacher from the very first day of my appointment.
So if you are a language teacher, if you are shown as a language teacher, then in place of number 3, you would have been provincial.
Yes, that is my case. And when the authority, the director has already in his affidavit, he said that Hindi is a language teacher. I don't understand, and my appeal.
What is the language of the person at serial 3?
Assamese. Yes. And my lord, over here, my appeal was filed that I was wrongly shown as additional teacher because I am a Hindi teacher. There is no concept of additional teacher in 17 Act at all. But ultimately, I am surprised by the impugned order how the appellate authority also considered me as a additional teacher, my lord. And that was the whole case in the earlier proceeding. And luckily, my lord, this affidavit in the earlier proceeding was with me, which I have annexed, my lord, as Annexure 10. And I believe the state has taken this stand, which they have filed earlier, that Hindi is a language. And if Hindi is a language teacher, my lord, then I come in.
How many language teachers are there?
My lord, actually,
To be, what is the number of students?
my lord, number of students comes with the people teacher ratio. It doesn't come with the subjects. If it is more than 100, then there is automatically 4 teachers. Headmaster is compulsory.
So how many students in your?
How many?
How many students? How many people?
64, less than 100.
Like that.
68, my lord, less than 100. So they have taken only 3 teachers correctly.
Yes. You are for?
I am in item number 86, 87 and 88.
Not in this matter.
No. 83. I'm not in 83 here.
What
In 86, 87.
Here, Lordship, section 3111 provides for only 3 teachers. Lordship, may kindly.
So and where is your original appointment order?
My.
Yes.
My lord, Annexure 1, my lord. My lord, page 25 is the typed copy, and your lordship, with the handwritten one, I can read it, my lord, if your lordship permits.
Yes. Then where is the provincialization order or subsequent order? This is by the SMC.
Yes, my lord.
SMC.
Yes, SMC.
Then subsequently.
Subsequently provincialized, my lord.
So
my name, this annexure, my lord, 31, annexure 4, page 31 is the DLC report, my lord. And page 35 is the provincialization order, my lord. My lord, before that, I would like to draw my lord's attention to page 34.
report.
34, my lord, serial number 11, my lord got it, my lord.
Yes.
My lord, this is the school at question now, before my lord. My lord, over here, 4th teacher is Kitish Chandra Rava, written additional teacher. And date of joining is 2/3/2003, whereas Muhammad Rafi Mullah is a shown only language 12/12/2005. And
when did you apply for correction?
my lord, I filed an appeal before before the director. That was a wrong appeal. And after that, I came before this honorable court, and this honorable court said your appellate forum was wrong. So you go for a proper appeal. Then I filed the appeal. And in the appeal, my sole ground was that I was wrongly shown as an additional teacher. And the impugned order, after looking at my appeal, was passed, saying your provincialization cannot be taken because you are an additional teacher. And concept of additional teacher is not there in 17, and that is the only plea I said.
Why was the shown as additional teacher?
Yes.
Lordship, that additional teacher perhaps by the managing committee, Lordship. Otherwise, section 3111 provides for 3 teachers for provincialization. One is for science and maths, one is for social studies, and one is for, there is only provision for 3 teachers. If the
One is science
and maths, one is social studies, and one is languages. That languages comes in the
It is his claim that he is
Lordship.
the language teacher.
Lordship.
But was shown as additional. So therefore, everyone proceeded with it. Additional teacher. There is no concept.
Lots. Lots of otherwise, in this matter, we have to file affidavit also, lots, because the fact is different here. Perhaps in every matter, some facts are different, lots. So we need to file individual affidavit.
But your affidavits individually will not come to the next file.
Otherwise,
We permit you to file for next 5 years, no affidavit will come.
But the affidavit which I have shown, that was filed in this case only.
Consolidated affidavit.
My lord, the affidavit which I have shown, this is filed in this case only, in respect of this petitioner only. The affidavit which is page annexure 10.
which is clarified in paragraph 5, Lordship, page number 58. That in the said structure of teachers in upper primary schools, the headmaster as well as assistant teachers were mainly to teach Assamese and English language, and no specific qualification required to teach English and Assamese language. But a specific qualification is required for the post of Hindi teacher and Arabic teacher to teach Hindi and Arabic language. However, as per section 3111 of the Act of 2017, there is a limitation of 3 teachers in school. One is science and mathematics, one is social studies, and one is languages. As per section 13(6) of the Act, the district scrutiny committee recommended 1 teacher.
If there are more than
Lordship, there is a provision for additional teacher, Lordship. May I take your Lordship to section 3111?
it's 2018.
2017, Lord.
2017, my lord.
2017. Section 3111.
This is
Page number.
provincialization and reorganization.
Lordship, provincialization and regulation. Page number 111, Lordship.
Yes.
Section 31. In case of 11, Lordship. In case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for A, science and mathematics, B, social studies, and C, languages. Provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule of section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. So therefore, there is a provision for additional teachers. If the students' enrollment position goes beyond 100, Lordship. So in the instant,
My lord, if it is the same book, then your lordship may come to page 127, where is the schedule, my lord.
How many students are there for Hindi?
60, all compulsory.
Compulsory.
Yes, yes. Hindi is a compulsory subject.
And Assamese also.
Yes, my lord. English, Assamese, and Hindi compulsory. If it is a madrasa, then Arabic also becomes a compulsory.
but Act provides only 1 language teacher.
So that more than one will be decided on the basis of what? Seniority.
Yes, they've taken the stand.
On the basis for additional teacher enrollment.
No, let us assume that both are language teachers.
Lordship.
Then you have only one.
Lordship. In that case, seniority, date of joining. Lordship.
So his claim is that only that he's been wrongly shown as additional teacher. He's actually a language teacher.
Lordship. So let me file affidavit, Lordship. And moreover, perhaps today it has come in orders. Lordship.
But my friend read paragraph 5 of his affidavit, but did not go to 6. Is he going to change his stand of paragraph 6? That is page 58.
Your affidavit is already here.
Yes, in the earlier case. But in this case itself, I believe my friend took the same stand as it was given earlier. Page 58, paragraph 6.
Let this be examined by the
Lordship,
authority.
Lordship, Lordship.
Let the matter be examined by the authority. Then if your nomenclature has been wrongly made,
Yes,
then
by the DSC as well as by the appellate authority, my lord.
so who is the authority to examine?
First is
In this case, your lordship, in item 86, 87 and 88, I have already filed my affidavit. But my friend said
No,
that
no, in this matter. All these matters have similar issue.
All Hindi.
I think all related to provincialization, but perhaps the facts may be.
What happened to the tribunal?
they have never approached before the tribunal. Initially, in the year of 2018 DLC meeting, there was, and DLC recommended them as additional teacher, but they have not challenged that. And our services provincialized in the year of 2021, and almost after 1 year, they have filed this petition, claiming that Hindi is also included
No,
within
that
the
is not their thing.
within the
Government.
yes.
And
The government
But
was-
so for the affidavit, your lordship, this affidavit in para 59, your lordship, all the statements are made from the knowledge. These are not from record, your lordship.
You are not there in the matter.
And
No,
Lordship.
I-
And Lordship, respondent number,
These are the analogous material, lordship, therefore only. I am in 86, 86, 87 and 89.
respondent number 7, here is perhaps the another language teacher
Who is
whose
in
provincialization
item
has been
79?
challenged.
79 who appeared? Your appearing. What is your case?
I am appearing in 79, 80, 81 and 82, your lordship.
All right. What is your case in 79?
My case is that in this petition, item 79, your lordship,
You are claiming for provincialization.
provisional service of the petitioners who are Hindi teachers, your lordship, and they have been deprived from getting the benefits of provincialization.
Why?
That is not specifically stated. What is the practice that, your lordship? Most of them are serving for more than 15, 20 years, your lordship. And under the Act of 2011, your lordship, if Hindi teacher is not there, that school was not even considered for provincialization. Because Hindi is a compulsory subject, lordship knows. Throughout the ME section 5, 6, 7 and 8, Hindi is a compulsory subject. And to teach Hindi, your lordship, there is a requirement of special knowledge. Like there must be COVID, Bisharad in Hindi or Hindi COVID, your lordship. Now, when the provincialization started, your lordship, these Hindi teachers, they have not been considered almost in all schools. Most of the Hindi teachers' cases have not been considered. Now, in that regard, before
Who
provincialization,
is to consider? What is the process for provincialization? Procedure.
through the district level scrutiny committee, your lordship, that has to come.
So was it not up in the district level?
It was put up, your lordship, but their cases were not recommended, your lordship. Just I will refer to one letter at page number 118, then written by the director to the government, seeking a clarification in the Act of 2017.
Show us one recommendation or non-recommendation of the district scrutiny committee.
It is in their
Lordship,
affidavit.
we have filed our affidavit in this matter, Lordship. Affidavit filed by the director of elementary education, Lordship. There are in total the 63 petitioners in this particular writ petition, Lordship. And if your Lordship may come to page number 3 of the affidavit, paragraph 7. So there are different status of different petitioners, Lordship. Paragraph 7, I will Lordship affidavit.
Yeah.
With regard to the statement made in paragraph 7 and 8 of the writ petition, the answering department begs to state that as per report of district scrutiny committee, the names of 50 petitioners as detailed in Annex 1, the detail is there, were not recommended by the district scrutiny committee Dhubri for provincialization of their services as per Act of 2017. So 50 petitioners, their names were not recommended. Further, as per report of the district scrutiny committee, the names of 10 petitioners as detailed in Annex 2 were recommended by the district scrutiny committee Dhubri for provincialization of their services in their respective schools. However, the state level scrutiny committee could not recommend their names for provincialization as tutors
for their schools as they did not fulfill the enrollment criteria as laid down in the act. So because of the enrollment position of the school, their names could not be recommended by the state level committee for in respect of 10. And remaining 3, the names of petitioner serial number 14, Rahimuddin of so and so madrasa and Abdul Aziz of so and so madrasa of the writ petition were not found in the report of the district student committee, and the Dhubri and Gwalpara, their names were not there in the district student committee. And the remaining 1, the name of petition number at serial number 45, the writ petition Abdul Alek Sarkar of so and so school was recommended by the district scrutiny committee. The state level scrutiny committee recommended 3 teachers.
Do you find that recommendation?
Lordship, annexed is there, Lordship.
In cases of individual schools,
Individual schools recommendation.
how
Lordship,
they?
Lordship. Lordship. Asal. Okay. 79. It is there, Lordship, in format.
First,
Lordship, kindly come to page number 10, Lordship. Affidavit.
page number 10.
Lordship. Format for report of district scrutiny committee.
Yes.
Serial number 7. These are the Pulin Chandra Roy, headmaster, language. This is the enrollment position. The status of the post, whether so and so.
This shows 3 teachers
Lordship.
as eligible, 3 teachers be eligible for professional license,
Lordship.
and teachers that are not eligible for.
Lordship.
What is the reason for that? Whether the report give the reason why
Because,
we went
Lordship, because of this enrollment position, Lordship. Lordship, kindly enrollment position 2014, 2015, 2014 it was 98 below 100. 2015 it was 82. 2016 it was 83.
So below 100.
Below 100. Lordship.
Below 100 means 3.
3 teachers.
And even the headmaster is not provincialized. Column below, HM.
Lordship. Column below is details of teacher who are not eligible. So even the headmaster, because in the Provincial Act there is no provision for headmaster.
It's only subject wise.
Only subject wise.
So apparently there are 3 languages.
Lordship.
Headmaster and
Headmaster also teaching the language.
Now, if you look into the right hand most column, status of the post, whether first, second, or third.
Lordship.
Insofar as language is concerned,
Lordship.
teachers who are provincialized,
Lordship.
you will find it is marked as 2, means second post.
One is Lordship. Language 2, social science 1, and science and math. Status of the post, whether first, second, or third. So these 3 posts are filled up. These are the posts. 3 posts. One for science and maths, one for languages, and one for social science, social studies. So these are the 3 posts. 3 posts. It signifies posts, Lordship. These recommendation scrutiny committee report is there school wise. In 70, item number 79, in this particular affidavit is there. In other matters,
79.
79.
Your affidavit is already there.
In 79, there is affidavit.
Ah.
In rest of the matters in the series. Because facts may be different in all the items.
How many matters are there?
79 to 88 losses, there are 9 matters. 10 matters.
Yes, but
Yes. Now, the question is that, your lordship, how many languages are there in an?
no. The question is they made a prayer for filing the affidavit. Now, if the matters are taken up together, then we have to decide whether the affidavit is required.
A time frame may be given and they may file in the meantime, your lordship.
Bunch of respondents, department, like, file, complete the affidavit. Which matters have you filed?
Item number 79, WPC 3597 of 2021.
And
Only this matter. there is
what
a-
about the
Lordship,
that is also filed?
that is filed in respect of the previous litigation, Lordship. Six, in earlier proceeding, the affidavit was filed,
Not in the
not in this present proceeding.
It is submitted that only in WPC number 3597 an affidavit has been filed. Rest of the matters have been filed. Haven't fixed time, having placed time with their instruction as well as the meeting, exchange the meeting. The meantime, let the matters be, let the meetings be exchanged and the matters be fixed after 4 weeks.
Lordship.
The parties are at liberty to complete their instructions and file counter affidavit. It's so just after 4 weeks. Yes?
First of all, your lordship, I seek your lordship permission. My name is not there on behalf of S.C. Vishwas, your lordship. I am challenging my impugned transfer order, your lordship, transferring me in the same capacity as in charge headmaster from Kachinimara, Jordanga ME Madrasa to Joleshwar ME School, your lordship. Basically on white impugned order dated Annexure 6, page 29, your lordship. Page 29. Page 29. Basically on 4 points, your lordship. One is that replacement of ad hoc employee by another ad hoc employee. Number 2, I am at the verge of retirement, your lordship. I am going to retire in 31st January 2026, your lordship. And
26.
26.
26.
1.5 years. It is about 1.5 years. The statement is state that before 3 years should not be transferred for facilitating the processing of pension papers, your lordship. Number 3, your lordship, the impugned order says in the interest of student and to maintain PTR and improve quality education. Your lordship, by transferring the private respondent to my school, how can the PTR be maintained? Already there are 345 number of students and there are 5 teachers. And again, there are also a resolution by the SMC not to transfer me because as in charge headmaster, I have undertaken some construction work of library, which is almost at the verge of completion. Yeah. So if I am not allowed to stay and complete those, there will be certain anomalies in the accounts, your lordship. Your lordship may kindly see SMC resolution. SMC resolution.
What if you had, you have superannuated? What if you would have superannuated during the process of construction? What would have?
Then I should have made an endeavor to complete before myself.
then-
Your lordship.
Yes,
Yeah,
where
the-
is the guideline?
SMC guideline, your lordship. The policy, though in our state policy, that one, there is no such provision that at the time verge of retirement one should not transfer, but it is an established procedure, your lordship. And another is one ad hoc should not be replaced by another ad hoc. And moreover, the respondent number 7, he has been given punishment transfer because there was complaint against him. I have annexed those complaints and he has been transferred and posted in my place
As the in-charge headmaster.
as internal, same capacity. I am also holding the post of in-charge headmaster. It is amounts to replacement of one ad hoc by another ad hoc, your lordship.
And what is the earlier order which was withdrawn?
These are tried to obtain, your lordship. These I could not collect.
Yes, what do you say?
Lordship, the order says in the interest of students and to maintain the people teachers ratio,
No,
Lordship.
but
Otherwise, Lordship.
you are transferring one
Lordship.
and replacing him with the
Lordship.
other.
Doesn't maintain.
So how the teacher-student ratio?
No change of status.
Let me have the instruction, Lordship. I will obtain instruction, Lordship.
Third learned counsel for the party. This petition is filed with the petitioner. Aggrieved by the order impugned dated 14/3/2024, whereby the petition was transferred and posted as in-charge headmaster Chalor Char ME School. Stop. Petitioner is an assistant teacher who is holding the charge of headmaster in Kuchnimara Jordonga ME School in the district of
South
Salman.
South Salman Mankajan.
Mankajan. And where is the other school?
Other school is also in the same district, your lordship.
Stop. Learned counsel for the petitioner submits that petitioner is a regular assistant teacher in the Kuchnimara Jordonga ME School and he is due to retire on 31/1.
31st January 2026.
2026. So, that apart. There is a policy, the state, the principle of which is also applicable to the employees in the education department. That ordinarily, a government employee shall not be transferred within 3 years prior to his retirement, superannuation. The learned counsel for the petitioner also submit that the impugned order reflects that the transfer is made in the interest of students and to maintain PTR and to improve quality education. So, it is submitted that there is no allegation against the writ petitioner. On the contrary, there are allegations against the private respondent. And therefore, one fails to understand as to how interchanging the petitioner with the private respondent and vice versa by way of this transfer order, the interest of the students and maintaining PTR or improvement of quality education needs to be maintained. So, it is submitted that this transfer order has been issued without proper application of mine, and the petitioner, being a regular assistant teacher, holding the charge of the headmaster in Kuchnimara Jordonga ME School, has been diligently performing his duties and has has to process his pension papers and his superannuity on 31/1/2026. As such, his transfer order he has caused him immense hardship. Therefore, he has approached his court, praying for appropriate direction. That Mr. P. N. Sharma, Learned Counsel, hearing the petitioner, responded, submits that he has no instruction. He is for some time completed instruction. According to it, you have to be listed again. How much time do you require? How much time?
2 weeks, Lordship.
Huh?
2 weeks.
2 weeks. Have to be listed again on 20
Lordship.
May. Enabling the learned standing council to complete his instructions. Till the next date fixed, the impugn as it is submitted to the petitioner. You have not handed over charge.
No.
As it is submitted, the petitioner has not yet handed over his charge. Till the next date fixed, the impugn order dated 14/3/2024 within bracket annexure 6 page 29. In order to facilitate completion of the instructions by the standing council, sufficient extra copies shall be furnished to the standing council within the course of this week. List again on 20.
Your Lordship, PG Kuchinimara Jordanga Emi Madras, Institute of School, it is
Emi
Madras.
Madrasa.
Obliged, Your Lord.
Lordship, a little 2 minute submission, Lordship, very different type of matter. Lordship, I was engaged in this case on 19 January 2023 because client said that earlier counsel has some personal difficulty, so to take a step. So accordingly, I have taken a step in the case, Lordship, on evident from the office note 9/12/2023 by the usual process. It's evident from the office note. Then the matter came to Lojima Court, Lordship, 12/6/2023. Lojima Court, Lordship, where I appeared, Lordship, but inadvertently petitioner name was not shown there, only respondent absent on that day. Thereafter, the matter came again in Lojima Court, 27/2023. That order is important, that may be fair, Lordship. 27/2023 order. In which it was found that service in respect of 5, 6, and 7 respondent was complete, Lordship.
6 and 7.
Yes, Lordship.
Ah.
I was appeared there. My name was also, I complained that earlier name was not shown. Thereafter, matter was listed on 26/7/23, Lordship, where parties, by the prayer of both the parties, matter was shown.
So it is to be listed for what? Admission?
Now, Lordship, why I am submitting, Lordship, because this order particular, 27/2023 of Lojima Court, Lordship, this order was not uploaded online, Lordship.
Oh.
Then the client alleged me that I have not attended his case, neither I have taken any steps. On that allegation, he took brief from me and also case with everything. And I handed over him.
You are no longer appearing.
No, Lordship.
It is you're Mr. S.B. Prasad.
S.B. Prasad, Lordship.
Mr. S.B. Prasad, Learned Counsel for the petitioner submits that the petitioner has taken away the brief from the Learned Counsel and accordingly he no longer represents the petition. Have you filed an application to that effect before the registry?
No, Lordship, because he has given taken NOC and receipt.
You filed it NOC before the...
No, Lordship, I will file.
The petitioner is permitted to file the NOC before registrar judicial. Stop. Since the petitioner has taken away the brief from the present council, the council no longer represents. Let the matter be listed after 4 weeks, enabling the writ petitioner to make alternative arrangements. Copy of this order may be communicated by the registry to the writ.
Lordship.
Mr.
R.B. Goswami.
R.B. Goswami.
Or respondent 120.
Respondent 120. Mr. R.K. Talukdar for accountant.
Okay.
Metro. Lordship, as per Loazima court's order, service of notice upon respondent number 6 is completed.
As per laws in the court order 29/4/2024, service on respondent 6 is being to be completed. Accordingly, matter be listed for admission. After
My lord, a date may be fixed, my lord. Family pension.
after 1 week on 13/6.
13/5, man.
13/5.
Obliged.
My lord, this is a review petition, my lord. My lord had last time had asked me the where my lord has mentioned the time with regard to that 6 months. My lord, that is at page number 45 of my review petition, where there is a direction of this honorable court that the entire amount has to be paid within 6 weeks.
Page number 45.
Page number 45, my lord.
Where is the direction? Paragraph?
Paragraph, my lord, paragraph 5, at page 45, it is observed that the entire exercise shall be undertaken and completed within 6 weeks from the date of submission of the certified copy of this order by the petitioner at the office of the respondent number 2, and having regard to the undisputed facts and circumstances of the case as well as the decision rendered in WPC so and so, for the unhesitated opinion that the petitioner case is squarely
You should
covered.
notice here. You should
My lord.
notice. Returnable 4 weeks. Mr.
SP Sharma.
SP Sharma appears to the review petition. Let steps be effected be taken on the respondent by registered post dating along with the equipment post within a period of 1 week.
My lord, may I just place it on, my lord, on the last Friday, there was a writ petition that was listed before this honorable court. That was 2/14/2024. My lord, in that, my lord has, this was the same kind of writ petition, but in that, my lord has not given a time period. And my lord has accepted the financial conditions of the APDCL and the joint consultative meeting. My lord, I however checked that order online, it has not come online. That would be very handy for this, my lord, it's the same matter.
When was the order passed?
My lord. (26/4/2024).
What is the WPC number?
2199 of 2024.
Okay. We have taken note.
Much obliged, ma'am.
Look.
May I please, your lordship? Lordship, you're on the last date on 23/24. It is directed to take steps upon respondent number 8. And
You have taken steps. You submitted that the steps on respondent 8 has been taken in terms of order dated 003/2024. Stop. Await service report is the matter after 4 weeks. MS
NN Sharma, lord.
NN Sharma appears
For K. Gogoi, lord. I'm appearing on behalf of K. Gogoi for CGC.
appears represents the CGC. MS
Sharma.
C Sharma appears for the writ petition after 4 weeks.
It is relates to deemed suspension matter. The petitioner Vikram Rothik was placed on a deemed suspension matter with effect from 1/8/2023.
Why is it listed today? For hearing?
My lord, what happened, my lord, on the last occasion, before due vacation, my lord, was what is my lord, left over. We made a mention.
There's an
my lord,
order that should be listed.
My lord.
Yes, what happened here? Suspended.
Yes, my lord, as placed on a suspension, my lord, with effect from 1/8/2023.
No, no review.
Review has been done.
Review done.
Review done, my lord. Review was done on 19/10/2023.
Yes.
And my lord, the SOCOS notice was issued on my lord 18/12/2023. That is after 90 days.
What is the status of the proceeding?
Lordship, on 13/3/2024, it was the date of preliminary inquiry. We have given notice to the petitioner also.
Preliminary inquiry. This is
No, Lordship, for some deposition of statement and all, Lordship. We have appointed inquiry officer and presiding officer in this matter, my lord. Lordship may fix the matter next week. I will get the present status, my lord, whether the DP has been closed or not. Next week, Lordship, I will get the written instruction.
My case is that, my lord, before reviewing the my lord, order of suspension, they have to issue the SOCOS notice within 90 days. That is
that
first.
is not according to me, that is not the law. That is not a
My lord,
individually applicable law.
I have understood, my lord.
It is not a case to case basis.
Yes, my lord.
Where you are suspended for months or years together, no review, no show, certainly it's a-
Yes.
But where there is an attempt to proceed in the matter,
yes,
some review is there, then some delay, or maybe the proceedings have gone, then you are entitled to challenge the review order if it's or that you should be placed, should be continued to be under suspension, you can challenge that.
My
Or you may challenge the disciplinary proceeding. But for some delay of 1 month, 3 months, I can understand 6 months, 7 months. Now there is a proceeding going on.
Yes,
During the proceeding, whether you should be placed under suspension or not, at the first instance, it's decided, authority they have decided. Have you, is that continuation of review under challenge?
My lord, as that has, my lord, lost its force, that has been reviewed for a period of 3 months. Within 3 months, my lord, second review was not done. Second review was not done within 3 months. So, my lord, a second review, they cannot do without, my lord, after 3 months, as held by this honorable court as well as by the honorable apex court.
Yes.
Lordship, we have filed affidavit. In fact, may I give the dates of the incident, my lord? The petitioner arrested on 1/8/2023, my lord. Then deemed suspension 5/8/2023, suspension order issued. Then petitioner got the bill 5/9/2023, and he has submitted representation to revoke the suspension on 21/9/2023. Then we have reviewed the suspension order on 19/10/2023 with effect from 1/11/2023.
For 3 months.
3 months. Then we have issued so-called charges had been issued on 18/12/2023, my lord. Then review of the suspension order 1/2/2024. Then we have appointed the inquiry officer, presenting officer on 5/2/2024. Now the process is going on to conclude the DP, my lord. Within a short period, Lord, we will conclude the DP, my lord.
After 19, there is another review.
Review, we have reviewed.
When?
Received the third review on 1/2/2024. My lord, I have a copy of this order. Lord, I have already submitted, I think, on last occasion. Since it's a case of bribery, my lord, so we will take some time to conclude the review.
It was done within 3 months.
My lord.
But within 3 months, my lord. My lord, they have reviewed the order with effect from 1/11/2023. My lord, November month is 30 days.
1/12. 1 One,
1-1
1-1.
and 1-2.
My lord,
Yes, within 3
on
months.
31st December, my lord, it is 61 days.
Yes. One.
61 days. On 31st January, it is, my lord, 92 days.
It doesn't say 90 days, it says 3 months with effect from
It's
3 months.
Yes, but my lord, the apex court decision is 90 days. Yes, ma'am. It is.
দেখলো না এখন?
Which decision?
My lord, page 43, my lord. There also will find the relevant paragraphs, page 46. Paragraph 10 and 11, my lord.
So this is with regard to the rules. The rule 10 prescribes review to be done before expiry of 90 days.
Yes.
Thus are these state rules prescribe that?
Yes.
Let us see.
Office Memorandum Laws will find, Office Memorandum Laws will find at page 14.
Page
14 of the compilation, my lord.
Page 14.
My lord.
It is within 3 months.
3 months. It says 3 months.
3 months, not 90 days.
Yes, my lord.
In fact, my lord, in others also.
Within 3 months.
In 3 months.
But
This
it
is how
beyond-
they have understood.
Yes.
111, your date will start from 211
Yes.
to 212.
With effect from 111.
So
It was review order was issued prior to that.
but you'll have to count from 211.
It will start from 111.
No, it will start from 111, but your counting will have to start from 211.
11.
How 111?
They have said with effect from.
Okay, 111, then 112.
112.
112 will be the first month.
Yes, madam.
1-1 will be the second month. 1-2 will be the third month.
Yeah.
So they have reviewed on subsequently. When have you reviewed?
Lordship, then
On 1-2.
1-2.
So strictly speaking, to say that 90 days has expired,
But my lord, as per
3
the
months.
as per the guideline, the Office Memorandum at page 14, it says that my lord, the Office Memorandum should be issued, the show cause should be issued within a period of 90 days, 3 months, within a period of 3 months. Then only my lord, the review will come. But they have not served the show cause to the petitioner, my lord, within a period of 3 months. It is beyond 3 months.
So that is what I was saying, that whether that arithmetical precision is required to be done here when the rules don't prescribe anything.
In the case of Adhyapak, my lord, this honorable court also, my lord.
In the case of?
My lord, A.K. Adhyapak, my lord, page 22, my lord.
There is another coordinate bench judgment. Earlier coordinate bench judgment, where it has been held that this 90 days is not to be calculated with arithmetical precision. It has been clearly held.
In the case of Rafael Ali, my lord.
No, not Rafael. You have a look here. No. Atfur Rahman.
Yes.
In Atfur Rahman, it has been clearly held. WPC 6842.
Yes, sir. But,
it could be reported, perhaps. Reported, which is
I know that judgment.
So there it has clearly held that this is not.
The authored by Honor Mr. Justice N.K. Singh.
Yes, it has been elaborately held.
Yes, long decision.
Now this judgment is not considered here. in Odhyapak.
It is prior to that. This
Huh?
Adhyapak decision is prior to Atur Roman.
This is when? 2018.
Yes, my.
And Atpur,
Atur is after this judgment.
you'll have to you see whether the judgment is considered or not.
Yes.
Right.
Here, my lord, paragraph 11, 12, 15, 19, and 20, my lord. So, lord, it clearly says
It is on that process, long and continuous period of suspension.
here also, my lord, the petitioner is under suspension since last, my lord, 8 months, my lord. He's sitting idle, my lord, and the government is paying his subsidy allowance, my lord, without any work. And this matter is, my lord, related to my lord, documentary evidence. The bidding has been seized by the authority. Nothing is with the petitioner. His reinstatement is not going to affect the disciplinary proceeding as well as the criminal investigation. If there is any criminal case.
Hmm?
Yes. His reinstatement is not going to affect the disciplinary proceeding as the documents are seized by the
No,
authority.
no. Had it been a case that no review, no show cause, you have definitely a good case for interference of the suspension.
Right.
But on the date when the suspension was, show cause was issued, or any date prior to that, you did not approach this court, did you?
I have approached this honorable court after before issuance of the so called notice.
Hmm. No,
So-called notice
sir.
was issued after that.
Anyway, let us see if you get your instructions.
My lord.
But state will have to, you already have a policy here.
My lord.
And you are not following this policy as I can find in several cases. We'll have to issue some strictures to the state.
I spoke to the authority lordship regarding that because of prolonged
That's the
suspension is
big-
always bad in law
There is
lordship.
judgments of the apex court that once you initiate a proceeding, then you must endeavor to complete it.
Lordship, lordship. Lordship, my lord.
When can you get it?
Lordship, next week, my lord.
Next week.
My lord, as per my lord convenience, I will get the instruction. In fact, my lord, lordship, it permit me to say, Ajay Chaudhary, paragraph 2020 cover my, 22 cover my case, my lord.
No, don't be so sanguine about it. It depends on the facts of the case.
Lordship,
Yeah, get your instructions
my lord, lordship.
on,
Lordship, I fixed some matters on 13, my lordship.
yes, 13th, list on 13th, by which date the respondents will endeavor to complete their instruction.
My lord.
We'll place the instructions with regard to the status of the disciplinary proceedings.
Lordship.
Stated to have been initiated in the writ.
Lordship. My lord.
I, Sokia for the petitioner and Ms. M.D. Bora for IWT.
Transporter.
Transporter.
Deeply obliged, my lord.
Obliged. Huh? Huh? What?
My pleasure, Lordship. The day though I submitted the discussion simply I felt that after Lordship kind enough to give me time. Then after going through, I have found this case is having little force in terms of the latest judgment of the Honorable Appeals Court held in Millard. It's state of Rajasthan versus Mangatlal Sidna, TV level 286 question 22 Millard. Here, discussion was regarding FR 54 2 Millard, because as soon as restatement was done, in fact, before that I'll take your Lordship, because Lordship may not bring it. Here the case, my lord, petitioner is an employee of the Home Department under the Government of Assam. While he was serving as a constable in the office of the respondent 6, that is Commandant 1st Battalion, Assam Police Battalion, Ligiripur in Nazira, my lord. Got it finally.
Yes.
While he was serving, he was placed under suspension with effect from 28/5/2003. That is annexure, my lord. I have annexed here. Annexure 1, page 12, my lord. You got it?
Yes.
Yes. Thereafter, after Department of Proceeding, annexure 2, which is last line.
No, the question which we asked you is whether his grievances have been redressed in the meantime, considering the matter has been pending for the law. That was the point where you were supposed
Yes,
to get
that is the point. Actually,
you have not been able to get
able
in
to
touch.
find out, because I have to go to, when I'll go home, then only I have to contact to Nazira. But here, most probably, because Lordship by affidavit, your Lordship.
See, unless there is something alive in this matter, why should we go into an academic exercise?
If suppose payment is made, my lord, that is your Lordship.
Yes, if his grievances are redressed, we'll close it.
Well, then that case, my lord, I get out to tomorrow. I'm moving to my native place, my nearby only Nazira. I have to contact personally and do the needful for that. Then maybe taken in next week, because otherwise, if not paid, my lord, it may.
No, that is the whole thing. How do we proceed? That
Yeah.
if paid, if not paid.
If not paid, is a very good case.
No, we don't know. It is for you to say.
No. It is if not
And
paid,
where
is a good
where
case.
where is the your counterpart?
Counterpart will be here.
CGC.
No, here, State of Assam.
Please find out what is the status, whether his claims have been settled in the meantime.
Yes, he is the best authority, my lord, to than me.
No, actually, you are the best authority because you are the petitioner, counsel of the petitioner.
No, because to get my client is very no problem is coming up, but he's getting his client, he gets easily. One phone call will help today itself.
Your Lordship, if we can supply me a copy of the writ petition, because I'm.
Give him a copy of
A copy of writ petition, affidavit also will give. If you get a legal citation also, which I am supporting, because it will be a leading case, my lord. Because I have gone to first time this type of case.
Heard done count. He is permitted uptime complete his instructions as to whether the claims of the writ petitioners have been paid, have been released in the meantime. He let these instructions be placed before the court. After within 2 weeks. You can do it within 2 weeks. The matter be called up in the week beginning from 20 May.
Hello. Like,
It will sound. It will copy to the-
oh, I did it in late.
Oh.
I did that, I did it.
Yes.
Oblige, Your Lord.
Yes.
The impugn order of dismissal, my lord, that is under challenge.
While sending out. Yeah.
The impugn order of dismissal, my lord. Well, in short, my lord, what had happened, my lord, pursuant to a disciplinary proceedings, my lord, the petitioner was an engineer with the ONGC. A major penalty was
So,
issued, my
but
lord.
again, dismissal is not before this bench.
No, I'm not aware.
No, the subject matter is listed. This is departmental proceeding.
Departmental proceeding.
Bench 3 matter. Bench 3 no.
My lord, just one request, my lord.
Are you playing for any claims?
My lord,
Suspension.
because of dismissal, my pensionary benefits and other benefits have also been, because in the meantime, the petitioner is superannuated.
Okay.
My lord, one request, my lord. So what had happened in this matter, my lord, there was some urgency in the matter. That's why an IA was preferred for early hearing, my lord. Lordship would see there's a corresponding IA, my lord, in the file. And there was an order passed in the IA, my lord, to list it for early hearing and from listed in the main list, my lord. However, my lord, I don't know what happened, my lord. The matter was never listed in the main column, main
It
list.
says disposed of.
Disposed
for
of?
Early hearing.
Granted, yes.
Early
So-
hearing of the matter, it does not mention anything about.
No, not because early hearing would mean, my lord, listed in the main.
No, early hearing means listed for early hearing in the hearing column.
The other side is also not present, my lord. But can it be, my lord, fixed in the main list, my lord, if possible?
Why? What is your
for-
problem in the part 2 list? Because main list, if it is not taken up,
My lord.
it goes out of the list. Part 2 will remain here for the whole
Yes,
month.
yes, in that case, my lord,
You're agreed by the.
I'm aggrieved by the impugn order of dismissal, my lord. In short, what had happened, my lord, after the order of penalty was initially passed, my lord, it was an order of reduction of 2 stages lower in time scale. Now, thereafter, because my lord, the client, the petitioner did not want to appeal the appeal against the penalty, my lord, he accepted the penalty, my lord. However, my lord, after 6 months, my lord, after 6 months, 25 days, the authorities have issued a show cause again for reviewing the penalty, my lord. So my point is that, my lord, as per the service rules, a suo motu review cannot be initiated after 6 months. So my lords have to decide if the
What is the penalty?
after the review, I was dismissed, my lord. The earlier penalty was reduction of 2 stages in lower time scale. I accepted the penalty, my lord. I accepted the penalty and my lord, joined my service, my lord. Thereafter, suo motu, my lord, a review order was, a show cause was issued, my lord.
There is the rule.
My lord, the rule, my lord, I have a copy for my lord. It's covered, my lord, the judgments. Rule 54, the entire rule is not there. We're concerned with 54, review by reviewing authority. It will be the last page,
54.
54,
55, I think.
No, 54, review by reviewing authority. My lord has it, my lord. May I read, my lord? The authority to which an appeal against an order imposing any of the penalties specified in Rule 34 lies may, in its own motion or otherwise, call for the records of the case in the disciplinary proceedings, review any order passed in such a case, and pass such orders as it may deem fit, as if the employee had preferred an appeal against such order, my lord. What I understand, in my humble understanding, my lord, that a review can be, my lords, on its own motion or otherwise. Otherwise signifies if the delinquent employee himself files a review. And on its own motion, and first they have to call for the record. Now, once the records are called for, my lord, only then a decision can be taken whether the order is to be reviewed or not to be reviewed. Now, it can also happen, my lord, with all due respect, my lord, that the disciplinary authority initially
When
calls
was the order of dismissal passed?
order of dismissal, my lord, page 112. It was issued on 12/9/2014.
12/9
2014.
and review
And I was show cause for review on 20/03/2015, which is admittedly after 6 months and 10 days.
20/03.
20/03/2015. And thereafter, my lord, the impugned penalty was issued on 26/08/2015, which is pursuant to the review, I was dismissed. So a more grave penalty was imposed, my lord. Now, the question is, well, what the other side, the stand taken by the other side, my lord. They are saying, my lord, that before the show cause notice, I was put on suspension, my lord. The date of the order of suspension is 9/03/2015. So what they are trying to say, that since that suspension was within 6 months, my lord, the suspension was issued within 5 months, 25 days. So they're saying that since the suspension was issued within the 6 months period, it would mean that the
You are placed under suspension post.
Yes, that is not, in fact, envisaged by the rules. I'll come to that, my lord. The order of suspension itself is without jurisdiction, but without even taking that point, my lord, that stand taken by the ONGC does not hold any water for one reason, my lord. They are trying to say that when we suspend,
Yes.
learned senior counsel, Mr. G.N. Sahewala and Anik Singh, my lord. Senior counsel, Mr. Sahewala appears, my lord, engaged by ONGC.
Yes.
So, my lord, what they are trying to say that the order of suspension would operate as if it has initiated the review. Now, in my humble submission, my lord, first of all, the order of suspension itself is without jurisdiction for two grounds, my lord. The first ground is that pending review suspension is not even envisaged by the rules. So, my lord is aware, my lord, suspension is normally 3 types, my lord. One which is a pen.
I don't know what the rules say.
Yes.
Rules are there.
Yes, rules are there, my lord. My lord, would see 54, that is the power of review. Review does not envisage suspension, my lord. My lord, what they have done, they have suspended me without any authority, and they are saying that the suspension itself would act as the date of initiation. But my lord is aware of KV Janaki Raman, my lord. Janaki Raman is very clear, although in a different set of facts, my lord, that a disciplinary proceeding is always initiated at the point when the show cause is served on the delinquent. In the instant case, my lord, apart from the order of suspension being without jurisdiction, the show cause was admittedly issued after 6 months, 10 days. So therefore, my lord, my humble submission, the entire impugned order is without jurisdiction, my lord. And there's another point, my lord. In the disciplinary proceedings, my lord, along with the petitioner, there were few other engineers who were involved, my lord. Same set of charges, same allegations, my lord. But they were dealt more leniently, my lord. My lord, I'll also be facing Bongaigaon refinery case, my lord, which says that if one fish stinks all these should be, if one person is, if a team is liable for a misconduct, everyone has, there has to be parity in imposing penalty, my lord. I mean, otherwise also, my lord, on the ground of the limitation itself, I have a very good case, my lord. I'll place the judgment, my lord.
So let the other side be
Yes.
present.
My lord, if my lord permits, my lord, I would inform the other side if my lord fixes a date, or I'll tell them, my lord, it will be taken up whenever there's de-annexing and learned senior counsel, Mr. Sahay, my lord.
What was your third contention?
My lord, parity, my lord, parity of penalty.
Parity.
This is not the case of ONGC, my lord, that the show cause is beyond limitation. They say it's beyond limitation. But their contention is that that initiation, as envisaged in Rule 54, would be the date on which I was suspended. And on that ground, my lord, I say that the suspension itself was without jurisdiction first. And second, there are judgments, Supreme Court and other High Court, which clearly says on this point, my lord, clearly says that the limitation for review, the reference would be the date of issuance of the show cause. And the reasoning behind it, my lord, I may point out.
So when was the penalty imposed?
Penalty was imposed on 12/9/2014. Thereafter, I was reinstated. I continued with my duties. And on 9/3/2015,
Penalty stoppage of 2 increments.
stoppage, no, my lord, reduction of 2 scale, lowered in time scale for 2 years, which is also a major penalty envisaged by the ONGC. Thereafter, my lords, while I was working, my lords, all of a sudden on 9/3/2015, I was placed under suspension in contemplation of review. Your suspension order says in contemplation of review, and 9/3/2015 would make it 5 months and 25 days from the date of the penalty. And 54 does not contemplate suspension.
Review under rule?
54, my lord, of the ONGC CDA rules.
Then when was the review order passed?
My lord, before the review order, I was show cause, my lord.
When?
On 23/2015. The show cause is beyond limitation, that is 6 months and 10 days. And the impugn order, my lord, thereafter was issued on 26/8/2015.
So when is the impugned order?
It's 26/8/2015.
Dismissal.
Dismissal from service, which would act as a bar for any further government employment.
Yes.
My lord, there are judgments on the same context, my lord, which clearly it discusses the carry material rule, and it comes to a finding that initiation of review would be from the date when the show cause was issued. And the reasoning behind it, my lord.
You furnish a list.
My lord.
You furnish a list of the judgment.
Yes. I'll furnish a list, my lord, soft copies and hard copies.
No, just give us a list. We'll get copies out. Yes. Heard Mr. P. Mahanto, Learned Counsel for the petitioner. However, none appears to the respondent department. The petitioner is aggrieved by the impugned order of penalty dated 26/8/2015 issued by the ONGC, imposing a penalty of dismissal from service without
Further, my lord, dismissal would be a bar for further employment, my lord.
which will operate as a bar for further employment under ONGC.
My lord, normally in all services, as that may not.
So
I'll just
what's
check.
the order of dismissal?
Yes, please. Under the Assam rules, my lord, it acts. I'll just check. Give me a moment. My lord.
Which will operate as a bar for further employment.
The
So
nature of
it is submitted by the Learned Counsel.
Net
That initially pursuant to the disciplinary proceeding initially, the penalty of stoppage of penalty was imposed, which is a weighty
Reduction.
penalty, namely reduction of
two
time scale. 2 time scale.
2 scale, lower in time scale for 2 years.
Lower in time scale for 2 years was imposed to the petitioner. So petitioner accepted the penalty, did not find the stop. He was reinstated in service. Subsequently, while he was in service, he was placed under suspension by the order dated 9/3/2015, purportedly in contemplation of a review to be conducted under Rule 54 of the ONGC. So and so stop. Thereafter, on 2003/2015, show cause notice was issued to the petitioner. And on 26/8/2015, the earlier order of penalty was reviewed, and penalty of dismissal from service will operate as a
My lord, it says dismissal from service, which shall ordinarily be a disqualification for future employment under the government or corporation, company owned or controlled by the government.
or disqualification for employment under the government or a company
owned by the government
or controlled by the government. So it is this order of penalty imposed pursuant to the privileges and the challenge. Learned Counsel for the petitioner has urged primary three grounds. Namely, that the power to review any penalty suo motu, which is vested on which is permitted under the rules on an authority who is ordinarily competent to hear an appeal, shall not be exercised after 6 months from the date of imposition of the penalty. So, since the penalty order was imposed on 12/9/2014, the show cause was issued on 2003/2015. Show cause for review was issued on 2015. The same is barred by limitation under Rule 54, the ONGC rules. Stop. And therefore, all consequential proceedings thereto is not permitted under the rules. Stop. The further contention of the petitioner is that the petitioner was placed under suspension on 9/3/2015, which is pursuant to the penalty imposed that the petitioner being reinstated in service already, in contemplation of the proceeding by the ONGC under Rule 54. Top Learned Counsel submits that such power to place the petitioner under suspension is not prescribed under the rules. The rules prescribe the power of suspension under
Rule 33.
Rule 33, which clearly lays down the circumstances under which any employee can be placed under suspension. So, proceedings, contemplated proceedings under contemplated proceedings for review of penalty under Rule 54 is not one of those conditions. So, the third argument of the petitioner is that for the same incident, several persons were also proceeded against along with the petitioner. So, however, the other persons have all been dealt with more lenient, save and except the petition, where it is submitted where the incident, it is for the same incident.
Same incident, Malad, same.
It is the same incident, the allegations are same. There is no occasion to use a differential standard in respect of the petitioner for proceeding against department. Stop. The respondent ought to have imposed the same degree of penalty as have been done in cases of other employees against whom the proceeding has been initiated. Stop. In any view of the matter, petitioner had already accepted the earlier penalty of stoppage of increments in 2 time scale for 2 years, and consequently no appeal was preferred. So, it is under these circumstances the current government has urged before the court to issue a writ to interfere with the impugned order of dismissal post the order dated so passed by the appellate authority in review. So,
one more ground, Lord, would kindly add. I'll clarify on doctrine of proportionality also. Too harsh.
Part of proportionality. Say that third ground, and therefore the punishment imposed is completely disproportionate to the allegation made against the petition, finding that it should therefore be set aside. Therefore, we should have been Vera. Although the matter was heard at some time, however, further hearing is deferred on account of the fact that the respondents are not represented today, although the names are reflected in the consensus. Accordingly, matter be called up again next week for further hearing.
Part 2 list itself, Malad.
Part 2.
Yeah. Can it be the next week, Malad? Kindly, Malad. Next week.
In the week beginning from 13.
Yes, very grateful, Malad. Deeply obliged.
Lordship, my senior is laying on another court.
You are there. You argue. You argue.
Lordship, I have not gone through the file.
We'll help you. If number file to you. You go to the file now. We'll take it up after 15 minutes. Okay? Then if you don't argue properly, we'll allow the repetition.
Lordship, kindly fix the matter tomorrow.
Tomorrow, provided you argue. You'll argue the matter, we'll fix it tomorrow. Yes. We will not allow your senior to argue.
My case is that losses petitioner was enrolled as rifleman. He was dismissed from service under Section 20 of B of the NDPS Act. It was challenged before this honorable court. This honorable court set aside the dismissal order, directed the author to reinstate petitioner will submit a voluntary application, and it was accepted. But while they are providing the pension benefits, they deducted that period. Lordship, may kindly we see the page 16 of this honorable court order, relevant portion, page 20. Page 16 of this honorable court or order, Lordship, that was set aside.
No, what is
This was a direction.
what is
part-
your prayer before
My
the court?
prayer is that they have provided pensionary benefit, but this, from the date of dismissal to reinstatement of return, that period has been deducted. Court specifically directed
Date of?
Lordship,
Come again?
Lordship, here is the petition was dismissed from service. It was challenged. This honorable court set aside the dismissal order, and while dismissing the order, petitioner was directed to submit an application for voluntary. It was submitted and accepted by the authority, but while providing the pensionary benefits, they deducted the period from the date of dismissal to date of reinstatement. I am aggrieved on that part. And further, they have provided sixth pay commission, but I am entitled for seventh pay commission. They also admitted in their affidavit. Yes, the page 20, Lordship, may can be looked into paragraph 1.3, page 20.
Yes.
Lordship got it?
Yes.
In my opinion, when the petitioner has suffered the punishment of rigorous imprisonment, the second punishment of dismissal from service for the same offense is disproportionate, and since the petitioner's reply was not taken into account while deciding on the penalty, I hold that dismissal order dated 21/8/2003 is legally unsustainable, and the same is accordingly quashed. Consequently, the nature of the appropriate relief will have to be decided in this case. In his reply to show cause notice, the rifleman has expressed his intention to go on voluntary retirement, as he had rendered 18 years service then, and now the petitioner is aged about 44 years.
Where is that voluntary retirement order?
Voluntary retirement order is Lordship's page. Their reply, Lordship, and page 23, Lordship, page 23 of the petition. Discharge certificate.
Oh, there must be an order.
Yes, that is discharge certificate, and voluntary order Lordship will go. Lordship will find at page page 46.
This is reinstatement.
Reinstatement and page 12, Lordship, I am sorry, page 22, Lordship, and it's a voluntary retirement letter.
Page?
Page 22. April 2016.
On the date of, you were suspended.
Dismissed.
No, prior to dismissal.
Lordship.
What is your prayer for regularization of the period?
No, notionally fixation of pay, Lordship, for pensionary benefits. There is an order of this honorable court, Lordship, that is page
No, what is your prayer now?
Now, my prayer is that they have deducted a period from the dismissal period to the restatement period. That benefit has not been paid to me. I am entitled for that benefit.
How many months or years?
Thirteen years, 8 months, 21 days.
13 years.
Yes, Lord. In the discharge certificate stated, I have completed 28 years something, but while providing pension benefit,
What is the total period of service according to you?
lordships, 28 years, 28 years, 10 months, 14 days. They have counted 16 years, 2 months, 15 days.
They have counted 20 years.
But while providing pension lordships, they counted 16 years, page 28 of my report.
What is the rule where it says
Rule says lordship as since this all court specifically directed that national pay fixation to be provided to the petitioner is entitled for that benefit, but salary is not entitled since he, no service received by the department, but national fixation to be carried out lordship for that period. And as per service to lordship, 20 years minimum requirement for voluntary retirement, but it cannot be if it is accepted 16 years.
this is what we're saying, page 22, it says render 20 years or 30.
But from the date of appointment to date of reinstatement lordship, that 28 years. But in the order says I have completed 20 years. Also. They have admitted 20 years completed. But
Yes, you come prepared tomorrow. We'll take up the matter.
lordship on Friday, tomorrow second half revision was some case lordship I have. That is on Friday.
Friday.
Friday. Obliged, lordship.